be out of sight, out of mind.
Good morning, ladies and gentlemen. We thank you for your presence this morning and joining with the Leon County Board of County Commissioners. We welcome today for this workshop our commissioners who are here. I want to thank State Attorney Jack Campbell for being here, our county attorney, our county administrator, our assistant county administrator, and our assistant county administrator, and for all of you who are here. We have before us today a measure which has come to us before, a measure that has been trending across the state of Florida, various jurisdictions. No doubt here in Florida we have a kaleidoscope, if you will, approaches to the measure that we're considering this morning. So again, we pause to circle back to a matter of, Sheriff, you're welcome. Sheriff McNeil is here this morning, but we circle back to a public policy matter, which we have nibbled on before, and we have paused our nibbling, and perhaps time has allowed it to marinate, and we will see how it effectuates our thoughts this morning. So those things being said, Mr. County Administrator, with the exception of Commissioner Welch and I, these other people up here not used to being up this early, going to teach and stuff like that. So the two teachers are here, and we're not hurt. But our other commissioners, I think they're hurting real bad. So go easy on them this morning.
Mr. Chairman, I've got a 3-year-old, so I'm up at 5:30.
You win.
That qualifies. So we're real grateful for your assembly of legal, intellectual leadership for our community, and we'd love to hear as we bounce back and forth the give and take of our views shared. It's a wonderful morning to do such a thing. Mr. County Administrator.
Thank you, Mr. Chairman, Commissioners, and I'll just remind you before we get started, in terms of your agenda today, you've got this workshop, and following this at 10:30, you've got the workshop on jail population, and then a break for however long that is until your 1 o'clock comprehensive plan meeting. So with that, Commissioners, good morning. As you may recall, in October, the board requested this workshop to explore alternatives to incarceration for the possession of small amounts of marijuana. The workshop before you today includes an overview of the current legal framework related to marijuana possession, a discussion on diversion programs that are currently in place and available here in Leon County to provide alternatives to incarceration, and a discussion of ordinances that some local governments in Florida have adopted to provide a civil fine for marijuana possession instead of a criminal penalty. As you'll hear in today's presentation, Commissioners, marijuana possession remains illegal under state and federal law. However, there are some communities, as I've said, in Florida that have adopted ordinances to provide for civil fines in lieu of a criminal penalty or in lieu of incarceration. And that is because in those jurisdictions, the state attorney has agreed to utilize his or her discretion to not prosecute those offenses as criminal violations. And you'll hear from our state attorney soon. You'll also hear more about some of the legal questions and potential challenges there in those cases. And we're happy to talk about that. I'll also note that you'll see in your workshop materials before you that there is no one currently incarcerated at the Leon County Detention Facility for only a misdemeanor marijuana possession charge. That's important. No one currently incarcerated in the Leon County Detention Facility for only a misdemeanor marijuana possession charge. And that's due to the diversion programs that we do have in place. Again, that are administered by our state attorney and our supported by our local law enforcement and criminal justice partners. Commissioners, as the chairman noted, this board has been very engaged since very early on in these policy discussions, and you've remained so as the legal landscape has evolved pretty considerably, and you'll hear from our county attorney, Chastity Osteen, on that a bit more during this workshop. So commissioners, at the table with me this morning, of course, we have our Sheriff, Walt McNeil, State Attorney Jack Campbell. You'll hear from both of them in just a moment. Also with me today is Wanda Hunter, Andy Johnson, and as I mentioned, Chastity Osteen, our county attorney, who have a brief presentation all lined up and ready to go, and then we'll get right into the sheriff and the state attorney for their remarks. And as always, commissioners, we have plenty of time in this workshop for your discussion. And as I said, all of the folks at the table here will be available to answer any questions that you might have. And with that, Mr. Chairman, commissioners, I'll hand it over to Wanda Hunter to start the presentation. Wanda.
Good morning. Good morning, commissioners. Well, the county administrator did a very good job of telling you, sharing with you our overview, which I've shared with you on the screen. And we're going to start off by talking about the federal and state laws related to marijuana possession. When we say possession of small amounts of marijuana, we're referring to 20 grams or less. So again, the county administrator has already shared that in the state of Florida, with the exception for medical use, marijuana is still considered an illegal substance. And with that, I'm going to ask our county attorney to share with us the legal ins and outs of this law.
Good morning, Chairman, Commissioners. So there are some layers of regulation just to keep in mind as you're talking about this issue. At the very top, of course, is federal law. Under the Controlled Substances Act, marijuana, it's called marijuana. It's spelled different ways. It's the same thing as cannabis. Don't get confused by the terminology. It's all the same. It does not include hemp. But at the federal level, it is considered a Schedule I substance. That meets 3 different criteria under federal law. That means it has a high potential for abuse. There's no currently accepted medical use and treatment in the United States. And it lacks safety for use under medical supervision. Okay? So notably, the U.S. Food and Drug Administration has federal authority to approve drugs for medicinal use. So far, it has not provided such approval for marijuana at the federal level, which is in part the reason it's remained a Schedule I substance. Okay? It's generally illegal to possess marijuana knowingly or intentionally. And since it is a crime, there is a criminal penalty, and that is imprisonment of not more than a year, a minimum fine of $1,000 or both. And then those penalties escalate with subsequent offenses for possession of marijuana. Okay? So then you get to Florida law. It is still considered a Schedule I substance, except for medical use. Okay, so possession of 20 grams or less is a first-degree misdemeanor, punishable by up to 1 year in jail, a maximum of $1,000 fine, or both. Now, in 2014, as I'm sure all of you know, the legislature passed the CMCA, the Compassionate Medical Cannabis Act. Okay, and that set up a construct where qualified physicians can issue certifications for qualified patients who have certain eligible ailments to receive marijuana, including low THC cannabis or a marijuana delivery device from a medical marijuana treatment center. Now, after that, subsequently in 2016, voters approved Amendment 2 to the Florida Constitution, and that provides protection for caregivers, qualifying patients, physicians, medical marijuana dispensaries, and their staff to protect them from criminal or civil prosecution as long as they are complying and working within the statutory construct for medical use of marijuana. Okay? At the local level, some jurisdictions have adopted ordinances that give law enforcement discretion to issue civil citations resulting in fines for use and possession of small amounts of marijuana. I would like to note for the board that law enforcement and prosecutors retain the ability to exercise their discretion in the course of investigating and prosecuting criminal misconduct. Okay? This board really does not have jurisdiction to change that. Typically, dependent on buy-in from law enforcement agencies and prosecutors, some of those jurisdictions have adopted those ordinances. I do know of at least one instance where there's an ordinance on the books and it's not used, and that's because there is not buy-in from law enforcement, okay? So the other thing I would really like to point out is federal law preempts state and local law, and that's basically the crux of the issue here. So the state could change it and completely legalize marijuana in Florida. That would not change federal law, which still has marijuana as a Schedule I substance. And law enforcement and prosecutors, they enforce federal law just like they do state and local law. Okay? Federal enforcement. So there at times has been deferment to states that enforce marijuana law violations from 2013 to 2018. The federal government basically deferred prosecutions, except in certain cases, to the states. That changed in 2018. There was that previous deferment policy was rescinded under the Trump administration. With the current administration, there has been expression that they plan to reinstitute that deferment policy. Happy to answer any questions. Also, we have our resident criminal legal expert here to my left, who I'm sure can answer any other questions you have about the law as well.
Certainly. And before we ask our state attorney to speak, I wanted to talk a little bit about the 2 diversion programs that we have in place. Again, as the county administrator pointed out, we did a review of the detention facility from the year 2019 to current date and determined that there was no one detained on a marijuana-only charge, first-time offense. Now, there are obviously people within the facility, thank you, Andy, who have been charged with other offenses, and marijuana possession is among them. But again, for first-time offenders with no other charges other than the possession of 20 grams or less of marijuana, we found no one incarcerated with that single charge. And as I mentioned earlier, the state attorney has in place a couple of diversion programs. One is a pre-arrest diversion program. And some of you who were on the commission back in 2018 may recall the state attorney implemented this program after he expressed some concerns about the adult civil citation program that we had operated for several years. That pre-arrest program is really a model program that is similar to what is recognized by the state legislature, in that law enforcement, again, has a discretion to allow for an issuance of a notice, not a notice to appear, and I'll explain that later, a notice to require them to report to the state attorney's office within 4 weeks of having been found in possession of marijuana. Among that, within that process, when the person reports to the state attorney's office, the state attorney will review the incident and make a determination whether they qualify, again, having been a first-time offender, whether they qualify for the pre-arrest diversion program. And if they qualify, again, they are required to pay a small fine, complete community service hours, and if necessary, submit to a drug assessment, a drug screening assessment. And after they successfully complete the program, their charges are dismissed.
Excuse me, Wanda.
Yes, sir.
That word qualify, is that something like if they have good manners toward the police officers, that what qualify means?
Law enforcement can take that in consideration. Again, it is what the law enforcement officer encounters on the scene. You know, if it's someone who's cooperative, not disruptive or combative, then the law enforcement may exercise their discretion to recommend that program. Did I describe that correctly, Sheriff? Is that your...
I guess you're asking him. Yes, absolutely. No matter what our actions we're taking here today, the law still clearly states that it's the officer's discretion as relates to marijuana cases.
Right. So generally, depending on what the officer encounters with the person, then yes, diversion is an option for.
You see that right there. And this is a conversation within the family room at home. This is a conversation. This is the problem with the equal protection of the law, that behavior at the scene, its interpretation of cooperation or correct deference to what an officer may have thought was humble enough, bow down, respect, yassa, yassa, whatever. And that's a problem. In no two encounters could that possibly be an equal protection of law. So for pre-arrest, the pre-arrest program, if they qualify, I'm making sure and wanting to amplify for our board to note that qualification is not, do you have a GED, or did you, can you run the 40-yard dash in 5 seconds? No, it's the officer's interpretation of your behavior at that point, and if he thinks you good boy. Thank you. Thank you.
Certainly.
Yes, sir. Ms. Vice Chair.
Yes, Mr. Sheriff, just to reiterate what you said and make sure I understand it clearly, I was to just say that no matter what action we take today, it's still the law enforcement officer's discretion. Is that correct?
Yes, sir. When you get down to the crux of the issue as it relates to marijuana use, statute's fairly clear, and I think the attorneys said it at the very outset. What I want to do, though, is put a spotlight on the work that our state attorneys are doing, the county is doing with respect to trying to find alternatives to incarceration. And I think we're all moving in the same direction with the same desired outcomes.
Right.
We believe that by working together, we can identify those persons who are less likely to reoffend and try to get them in a different space. The issue of police officer discretion, while it is cumbersome, it depends on the mindset of the deputy or the officer at the time of the arrest. But I can tell you, by and far, now there are always exceptions, by and far, deputies, particularly deputies, I can speak to my staff, are cognizant of the fact that we are trying to reduce the population in our detention facility, and we realize that many of those persons with marijuana use don't necessarily need to go deeper into our criminal justice process.
Right.
I will also say that it's sometimes difficult to buttress that against the fact that Jack probably knows his numbers better than I do. While marijuana is in some regards, an insignificant kind of drug crime in some regards, but when you start looking at the behaviors in our community, it's significant to know that most of our shootings have a connection back to marijuana. And it's hard sometimes to make that pivot when you're a deputy out on the road or a police officer on the road, and you perhaps know more about the things that this person's involved in that surfaces through his or her use of marijuana. Particularly going back to the most recent case that I'm aware of is the FAMU student who was shot and killed, and that was a marijuana deal that went bad.
Thank you, sir. As I understood, just say one real quick. You said no one incarcerated on a first-time standalone charge of possession of 20 grams or less. I imply that to mean that, there are people there that maybe had 20 grams or less, but were incarcerated on another charge as well. So it was
Sure.
a couple charges.
With your permission, I can give you some real straight numbers on it. Thank you all very much for talking about it.
Well, real quick.
No one has been incarcerated since 2019 on a possession of less than 20.
Thank you.
Period.
I hate to jump out there early, But when we had this conversation, I was really interested in seeing where we were today versus where we were last year. I think the conversation that we're having and the thing we're trying to do here is to be effective in our efforts to make sure that our jail didn't fill with people with 20 grams or less offenses. Making sure that we don't put people, especially first time, in the system for something that most would consider to be minor. I would say that just sitting here listening to what we've listened to thus far and reading some of the things that I've read in the workshop item, I'm convinced that the system's not broken. If we had come here today and we were able to say that the sheriff and the state attorney were locking people away with 20 grams or less in large numbers, or even if there were 2 people in our detention center that were charged with such, then I think I would be in a different place. But it's going to take a lot of convincing here for me today to move me in a direction of doing something that just simply at this point does not seem like it needs to be done. So I say all that to say I don't think the system's broken. I appreciate the work that the sheriff and the state attorney have done to keep these numbers the way they are when it comes to 20 gram or less. I said it the last time we had this conversation. I'll say it again. I fully expect for us to have the partnership and continue to do that. Actually, given what you said, Mr. Sheriff, we're not even, no matter what we do here today, you still have discretion. But us trusting you by maybe in today moving forward with not implementing these or this level of ordinance is trusting that you will continue to do the work that you're doing in the way that you've done it. I think you're both men of your word. I don't think you go out there looking for people to lock up for no reason or to lock up for minor reasons. I think you look for major things and things that can prevent crime in our community and crime from growing in our community. As you said, Sheriff, very clearly that a lot of the killings that we've had may not be directly marijuana, but tied to it in some kind of way. So, but I would imagine that ties for more than 20 grams. I would imagine that ties for much, much heavier amounts of marijuana. So I'm not going to make a motion, but I just wanted the board to know that very early on, I'm not here to play a game or try to make it seem like I'm going to do something. It's not. I don't want to politicize this issue either. If we're being effective, we're being effective. If there's no one incarcerated with 20 grams or less, then I don't think it's. I think we can trust our law enforcement and our state attorney to continue that trend. And if they don't, then we can have another conversation. But right now, I'm just not convinced to move in the direction of creating an ordinance to stop a problem that we just don't have right now. Thank you, Mr. Chair.
We thank the Vice Chairman for those comments. Are there other commissioners at this point who want to weigh in? Commissioner Welch, Commissioner Cummings, and Commissioner Welch.
Thank you, Mr. Chair. I want to thank the state attorney, the sheriff, Ms. Hunter, and Mr. Johnson, and all of you all that have been involved in putting this workshop together. Great information so far from all of you, from our county attorney in reference to this issue. Having worked in the criminal justice system over the years, not real heavily, but over the years, I can certainly say that under the tenure of our present state attorney, we do see numbers that are very positive that we would not have seen as it relates to first-time offenders that we would not have seen prior to his administration, as well as the tenure of our present sheriff. So I agree with Commissioner Maddox that they are doing an incredible job in trying to keep the jail population down. They're doing an incredible job with the pre-arrest program and the post-arrest program. I have represented clients that have been involved in both areas, pre-arrest, post-arrest. And the state attorney does have people, the state attorney does have personnel in place that have always been willing, whether my clients were in the pre-arrest stage or after arrest, they've always been willing and cooperative to get my clients involved in the diversion programs. The diversion program works. I think the sheriff's deputies that have been involved with those arrests or with individuals that I've represented that did not have any prior on their record have been real active in steering those individuals to one of the diversion programs. And so I think from that standpoint that we are at a point where we want to be as far as not criminalizing those individuals who are arrested with less than 20 grams of marijuana. However, there is a perception in the community, in certain segments of the community, primarily the minority community, that has a distrust for law enforcement, distrust for the state attorney. And even though we know, based on the numbers that we have, based on the stats that we have, we know that we are chipping away from a statistical standpoint to get us where we want to be. But those elements in our community don't read these reports. They don't have the stats, okay? And while today we are considering whether or not to adopt an ordinance that would reduce some of the arrests to civil citations, okay? And if we consider that very seriously, my position is that it would do more to solidify a positive perception in the community, because I believe from a number standpoint, we are where we want to be. But I would support such an ordinance only if I could convince the state attorney and law enforcement to become involved. And of course, I recognize the preemption of federal law. I recognize the law is in the state as well as far as its possession. But I want us to think a little outside of the box and recognize that if our top law enforcement agencies here in Leon County come together and look at this as a way of demonstrating to the public that we are doing what we've always said. We want to close that gap that exists between those in the community and law enforcement. We want to close that gap of distrust. We want to demonstrate that we have taken positive steps so that we can have a positive relationship with members in the community. Now that might be a big step, State Attorney Campbell, for you to take, but that's how I'm looking at it. And of course, we know that perception is, what is the percentage? Is it 90% of reality or something thereabout? And believe it or not, and I think you all will agree with me, that a lot of the interaction in the community, a lot of the interaction with those individuals that are arrested, and if the interaction is negative, it's based on that perception, whether it's true or not. So I just think only if our chief law enforcement in Leon County would come on board and look at it from that standpoint would I support it, even recognizing that it's contrary to state law, contrary to federal law. Now, I also recognize that there are other jurisdictions in the state of Florida that have adopted such an ordinance. And I think those of us in the criminal justice system, I think we will all agree that the federal government is primarily interested in those individuals that possess more than 20 grams, because they are concerned with whether or not you're trafficking or whether or not there's an intent to sell. Less than 20 grams, I don't think they have any primary concern about it. I don't think anyone in Leon County would challenge the ordinance, but I think it would just solidify what we're already doing, and it would send a message to our people, to our citizens, and primarily our citizens in the communities that have this major distrust, merited or not. We know it's there, okay, for law enforcement, and I think it would send a resounding message to the communities, because it's a ripple effect. If something adverse happens to somebody in my family, or something we feel is adverse, because of interaction with law enforcement, it doesn't just affect that one person. It affects the mom, the dad, the cousins, and it gets around, this was bad, this is what happened, and it's going to happen. That's the sentiment, the feel, primarily against the minority community. So I just think it would be a great demonstration on how we are trying to address social justice. It's been a big outcry last summer with all the marches about social justice, and we are going to address it. We're going to come together, and we are going to try to correct the perception in the community. And I just think that would be a step toward that, Jack. Thank you, Mr. Chair.
Commissioner Cummings, and I would just simply take a few words to simplify what I think you were saying, and that is that for the years of which the war on drugs, being led by President Reagan, the war on crime, the perception that the war was on black people in America, at least disproportionately, the carnage of the war affected disproportionately high prosecutions, arrests, and I think that with respect to these programs, unless you're looking at those reports of how many women were stopped and given diversion and how many men were stopped and given diversion, but when you get into that gray area of behavior as the qualifying element and essence of who gets it, what is good behavior, in particular if just being a black man, period, is wrong. So there's nothing you can do to be so goody, to be goody-goody, to warrant and receive that. But to your point, and what I think Commissioner Cummings is talking about, is the continued war, the war on drugs, the war on crime. Has been a war perceived to be, and disproportionately it has affected minority communities. Commissioner Welch.
Thank you, Mr. Chair. Thank you all for being here, Mr. Sheriff, Mr. State Attorney. When I look at the issue, I have a couple questions. Number one, it kind of seems like, and I wasn't here in 2019, and I know you were elected in 2020, if I'm correct. No?
No, sir. I was elected 2016.
2016, I'm sorry. So my question, and I was going to give you the credit of saying when you came in, nobody was incarcerated 20 grams. What was the situation before 2019 in terms of people incarcerated on a first-time basis, standalone charge 20 grams or less? Did we have people in the jail in situations like that?
Mr.
I'm
Chair,
sorry, could
I
you
don't know
repeat
what
that question? Hold on, I missed the question. Could you say it again, please?
My question is, what was the situation prior to 2019 in the jail in terms of this issue of incarceration based on less than 20 grams?
Okay.
Chair. Candidly, I know that we had cases prior to the diversion program. When I came into office in January 2017, I redid the diversion program. I've got the numbers that have been done, and I'm prepared to kind of answer the questions, but I did not prepare the my administration numbers where we are. Y'all, staff, we're doing a 3-year look back. I can tell you in preparation for this meeting, I've got some historical, and for the next one, candidly, according to the Florida Department of Corrections, Going back to 2017, overall, we sentenced 913 people to jail. In 2018-19, we sentenced 239 people to jail. In 2019, we sentenced 225 people to jail. In 2021, 152. So I can tell you that if you see that going from 900 down to 152, our office has been trying to, in coordination with the sheriff and in addressing the issues that you have, to try to lower the amount of people going to jail. Conversely, once again, I can go back, and I'm prepared with some comments that I think may answer your question. Specifically, I don't know. Yes, there have been people who have been jailed. If you look at our diversion program, in 19, we had 367 people with marijuana cases. In 20, 83. In 21, 80. So far this year in 22, and I pulled these numbers as of today, we have received 27 cases so far this year. 21 are in my diversion program. One has, on the lam, failed to appear. One entered a plea no contest straight out of when he showed up for court. So he didn't want my diversion. He just entered a straight plea. And then I've got 4 that haven't decided. They may have come in last week. So they're simply mechanical. So we've got 100% of the people with marijuana who are going through the diversion program at this point, of the people that are diverted. And like I say, I'm happy to address each of what's been said, but there's nobody in jail for it. I'm running it cheaper than, and once again, I've been recognized on a statewide level. It's not costing the county any money. I'm doing it all internally. If you talk to others, they outsource it, and one of the balances that I tried to strike was the previous program was $200 per person. I cut it to $100 and put it purely inside, because I didn't want it to be a situation where there was a cash register where we were having disparity. I also have been able to do the fidelity throughout the 6 counties of the circuit, where we were mainly having Leon. I understand your constituents are purely in Leon. Mine also extend to the outlying counties, and its equality there is equally important to me. So it's $100. It's purely run by our office. We've had extraordinary success in it. To give you an idea, so far this year in 2022, the diversion program has handled 25%, 1 in 4 of all the cases in Leon County. 41% of your misdemeanor and traffic cases have gone through our diversion program at no cost to Leon County. That's purely what our office is handling. So 40% of the cases, the misdemeanor and traffic cases, which includes 100% of the misdemeanor. Now, there were some questions about mixed cases. I might have an armed robber who also has some weed in his pocket. No, I'm not going to put him in the diversion project. I also have DUIs where often there's a mixture. We do not extend DUI diversion in this community, and I can talk about that. That's a very deliberate situation that we're trying. Going to what the sheriff said, though, I'm also mindful of the violence that we have in our community he's right, I do have the exact. Tyler Whitwolf, Malik Whitminnis, Lamar Nelson, Wendell Feed, Kelvin Farmer Jr., and Anthony Bell Jr. are all of your constituents who were killed and murdered while doing some form of marijuana transaction in Leon County in the last 3 years. So the reason that I want to keep it criminal and all, Commissioner Cummings, I understand. Often the marijuana allows us to follow up, and that's why I want to empower my law enforcement, where it may be start off as a misdemeanor investigation because they're smoking a blunt and they have smell the marijuana. That may well lead to the fact that they find other types of narcotics, weapons, and I know that I have carnage in this community secondary to marijuana. Each of those people are current murder prosecutions, first-degree murder prosecutions that our office is handling in this community, where it was not just a drug ripoff, a marijuana ripoff that led to that homicide. So that's why I want to empower my law enforcement, because unfortunately, and part of this is uniquely Tallahassee, If you want to know what college kids are using, generally they're smoking more marijuana than other drugs. It's not a big heroin town. We have a little bit of fentanyl. We have methamphetamine, particularly in the out. But most of my college students, and unfortunately what's often happening, as you know, technology has kind of changed and we live in a cell phone world. And just like they can swipe left and swipe right to try to find romance, they will also go on the internet to buy marijuana. And they meet people for the first time, and that's exactly what the sheriff referred to. We had a beautiful FAMU cheerleader whose total death sentence was because she and her girlfriend decided to buy marijuana, and she is dead. And I will prosecute that as a murder. But what started the ball rolling, whether we like it or not, is the fact that she decided to, and I most likely, buy marijuana from somebody she had never met before. They knew that she would have money. On the other side, they knew that they'd have dope. And so most of the time when they're having these interludes, they're coming with firearms, and that gunplay leads to death. And so that's why we are working it. We are 100% of the clean, and I understand what you're saying. I believe in officer discretion, but once again, it's a double filter system. So the deputy on the scene, he's able to see the interaction, which of course my prosecutors never look at the person in front of them. It's just a paper. But they're able to sit there and decide, hey, I'm running this person through FCIC. He seems to have no criminal history, or she doesn't. I'm going to give you a break and not even give you a notice to appear. But even if they do that notice to appear, even if they were to take it that next step, there's a whole second filter where my prosecutors are able to go through our criminal justice system and say, hey, this person has no history, or it's a minor history, and we're going to extend. One thing that I want to correct that was brought up earlier was the suggestion that this is only a first-time offender program. That's not true. That is not true. We allow multiple people. Once again, under prosecutorial discretion, our prosecutors, we allow. So if I have somebody, for instance, who in 20 years ago had a possession of less than 20 grams, and now they're 45 and they're caught, well, no, I don't think that that's a perfect person to go through the diversion program. On the other hand, if I've got somebody who's been caught 3 times with marijuana in a month, we're probably going to need to add, and what Deputy County Manager brought up, some evaluations and treatment options, because if you're smoking enough that you've gotten caught by law enforcement 3 times in a month, maybe we need to step it up and you may have a problem going on here, or we can take that intelligence. So that's why, but going through the cases, and once again, it'll reflect on the next meeting. In 19, we're talking about 367 misdemeanor arrests. It's down to 80 the last 2 years, and once again, we're here in March, and we've all of your law enforcement, TPD, Sheriff's Office, FSU, 27 cases have been referred, and every one of them that was appropriate has been sent to diversion. And so we're trying to use that discretion both to help the deep end of the pool, because whether we like it or not, I got 130 people in the county jail right now who are on murder charges. And like I say, the number one dynamic of that is drug ripoffs. And that's just a reflection of where we are in our community.
Mr. Chair?
Commissioner Welch,
Thank you.
did that answer your question?
That was a very long answer to my question.
Okay.
My point in asking that question, Mr. State Attorney, was not to conflate murder with small criminal possession of marijuana and that whole answer. My point is simply, and I would rather we focus on the issue, right? The 20 grams or less. I get it. It creates problems. It starts instances that can lead to murder or other weapons possessions charges. But we're not talking about that. We're talking about 20 grams or less. My point in asking that question was to give you some credit, because I recognize that this process is evolving, okay, at a national, state, and local level. And that evolution is evidenced by your own numbers you just quoted, right? These prosecutions have come way down. The numbers in the jail have come way down. But I think it's relevant to understand that when we use terms like discretion and inconsistency with federal law, and we have states that have fully legal marijuana that the federal government defers the prosecution to the states, so nobody's getting prosecuted. it's a substantially gray area when we talk about the state of marijuana in a huge abstract way in this country. We have people, I have friends who have 20 grams of marijuana that they use for medicinal use because they have back problems or stress problems, yet people get arrested for having that. Now, I want us to recognize that we all kind of accept the reality that at some point in the future, more and more states are going to fully legalize marijuana. At some point, I would anticipate the federal government to deschedule marijuana. And so I think to Commissioner Cummings' point and to Commissioner Proctor's point, what we're considering is codifying at the local level what has essentially been codified, not codified, but in some way formalized in different states where marijuana is fully legal, or you have medicinal marijuana in, I was going to ask you how many states, but in the essence of time, for me, for us as a board, what this does by creating an ordinance is it does not really, I think we recognize it doesn't change the situation for law enforcement. You guys have the discretion to do what you need to do. You still have the discretion to divert and do what you need to do. But as policymakers and community leaders, it codifies for us our stance on the issue, which is I don't think it's fair for people to go to jail or be prosecuted for having 20 grams or less of marijuana in the world we live in today. This fluid, evolutionary marijuana world we live in today. And so for me, I will support the ordinance, not to discredit you or not to put you in a difficult position, but to reinforce my sense as a community leader that it's the right thing to do, and that's where we're going to be moving eventually. So it postures us in a position to sort of get ahead of the evolution as it comes, because it's going to keep coming. The change is going to keep coming in the way we deal with marijuana in this country. And so I think you guys are doing a great job, Mr. Sheriff, Mr. State Attorney. I think those numbers bear that out, right? But what it does, it's not a slight to you. It doesn't, we don't want to put you in a position where you cannot further investigate, where if you find marijuana, you can't further investigate for drugs or heavier drugs or guns or then violence. I recognize that a lot of the violent crime in our community is driven by drug use. I just want us to sort of codify locally this idea that you have the discretion, and we would prefer that you provide civil citations in lieu of basically just us saying we support what you're already doing. And that's my thought on that. So I had some other questions, but I will skip them in the sense of time. So
Commissioner Welch, your comments, I want to wink at you as I say this. I take courage in supporting your comments today. A great position which I share. I ponder, Commissioner Dozier and mine, you all care to weigh in. Okay, very good. I want to just, taking that courage to join Commissioner Welch, I wanted to ponder, how does law enforcement, the state attorney, in you all's association meetings, sheriff's meetings, recognizing 15 Florida jurisdictions and our students who, over 60,000 in this community, who come here with different understandings of the marijuana laws. Kids from Miami, Fort Lauderdale, Tampa, Orlando, other jurisdictions come to Tallahassee unbeknownst to them that they get in serious trouble, but in jurisdictions where they are from, they scale everything back to 18 grams and less, and they're really good. How does a law enforcement person, kids, show me your driver's license, okay, I'm from Fort Lauderdale. And I mean, immediately you know that they come from an environment that their law is not our law. And it's almost like whiplash for them to appreciate, well, here we are in Mayberry, and didn't know we were in Mayberry, thought we were in Florida, but not all of Florida is uniform. This is a dynamic of, I would say, the state legislature allows this lurch to occur, and to have a state half free and half slave with respect to the 20 grams or less being applicable to the interpretation of a civic versus a criminal offense. How do you all do that? But I'm not going to, I want you to come back to it, set it out there, That's the big question. And I know at your association meetings, you must bang heads on this. Commissioner Minor, then Commissioner Dozier.
Thank you, Mr. Chairman. And thank you very much for taking the time to be here. I know how busy you are, and thank you for everything that you're doing. Really appreciate it, both in the State Attorney's Office as well as the Sheriff's Office. Thanks to both of you and your teams. Since 2017, the State Attorney has effectively taken over the adult civil citation program that existed prior to 2017 and replaced it with the pre-arrest current program that we have. That's correct, right?
Yes, sir.
But according to our agenda item, there's not been any referrals to that pre-arrest current program since its inception, since it was taken over by the State Attorney's Office. Is that correct? For marijuana possession.
I don't know of any. Once again, that's prior my office. The program is in effect. Anybody that law enforcement did refer to us, we've never not taken and given them deferral when they have referred to us.
Okay. In our agenda item, and I'm just asking questions about it. In our agenda item, it says that the current program run by the State Attorney's Office has not been, the pre-arrest program, I'm talking pre-arrest, has not been implemented for people that might otherwise be charged with small 20 grams or less marijuana possession. According to our agenda.
That's incorrect. It has been implemented. If a deputy or officer found somebody with less than 20, they could refer it to our pre-arrest program.
Do you have a sense for how many offenders have been offered that and have taken advantage of it?
Very small.
Very small, okay. Do you know why that is? Is it because law enforcement typically uses the post-arrest diversion programs instead?
I can't speak, and once again, I believe in allowing the officer on the street to have the discretion that they do. Once again, in a practical, the officer always has a discretion of pouring out the beer that they catch the high school student with, and then I never know about it, all the way up to taking them to jail. Same thing with marijuana. So I don't know why the officers use their discretion, nor is it in my gambit as your state attorney to do that. They have, as the sheriff has said, they could make a federal case. They could charge them under state law. They can, and if you pass an ordinance, they will have one other thing they could charge them with. That's one thing that I think Ms. Osteen referred to is it wouldn't change they would now be guilty of 3 crimes instead of 2. Mm-hmm. Yeah. Is by adding an ordinance, there's no way for you all to subtract. You would just be, the person now would have yet another crime that they would be charged with. They'd be violating Leon County Ordinance 1345, Florida Statute 893, federal statute, whatever the federal. So that's kind of the point of where the sheriff and I are. The officer at the scene will still retain the ability to arrest on that scene based on Florida law, and that is statewide.
Okay. And then, and as you described a few minutes ago, I think with Commissioner Welch's questioning, the post-arrest diversion program has been really effective. Our agenda item says, 250 offenders have taken advantage of the post-arrest diversion programs over the last 3 years, which is terrific. I realize that the county commission does not have the authority to decriminalize possession of small amounts of marijuana. That's been stated already. We don't have the ability to compel law enforcement to issue civil citations or fines. But why wouldn't we want to provide you, Mr. State Attorney, and Sheriff McNeil with another tool in the toolbox? Why wouldn't you've got the post-arrest diversion programs, which seem to be working quite well. You've got the pre-arrest diversion programs, which have not been exercised often by law enforcement officers, but are available at the discretion of law enforcement. Why wouldn't we provide another tool for you to use in your toolbox? And that's a question both for the state attorney and for the sheriff.
Sheriff, I don't know if that thing's working or not. I guess the red button is working.
Yeah.
The question for me, quite honestly, Commissioner, is not whether or not we get another tool in our toolkit.
Sheriff, you speak a little less. Come closer to
To give us 3. The issue to me, quite honestly, is how can we more effectively use what we have? and that is the civil citation program. I've instructed my staff, after looking at the number of civil citations that we issue, from my perspective, therein lies some of our problem and issue, that if we were more effective in issuing civil citations and did a better job, and I'll admit that from my perspective, I haven't done a good enough job looking at the opportunities we have in our community to issue civil citations and get the kind of results that we think we should receive. So while adding another violation, you indirectly, if we have, and we have deputies and officers of different perspectives when it comes to dealing with these drug problems. So instead of, as Jack indicated, Mr. Attorney and State Attorney indicated, now my deputy, who really wants to get these people off the streets, charge them with 3 crimes instead of 1 crime. And so I'm not sure that the fix actually achieves the fix that you're looking for. I'm not, so much opposed to it, but I believe that the civil citation program that we have, and quite honestly, I'm biased by it because I helped create it many, many years ago. And I've been surprised that we don't use it as much in Leon County as some of the other counties, particularly in South Florida. So my perspective on this is, and what my takeaway, and I've already given direction to Assistant Sheriff Gilmore, one of her charges, is to make sure that we increase the number of civil citations we issue, because I've been really, it's an abysmal number in terms of how many opportunities we have for civil citations and the civil citations we issue. I'm not sure if that answers the question, but that's.
Thank you.
And the one thing kind of following on that, one of my concerns is, to Commissioner Proctor's point and to yours, is that while if you pass a Leon County ordinance, it will be worked in Leon County. I will then have 5 counties where the law is different. And there'll be one state attorney, me, and I will not be able to treat the people of Gadsden County the same as I can in Leon County. So that's why I will be consistent. I can tell you, and this is all due respect, you can certainly pass the ordinance, but I took an oath to follow the law of the state of Florida, which is my entire jurisdiction. And I'm going to treat the people of Franklin, Wakulla, Jefferson, Liberty, and Gadsden County the same as I treat the people of Leon County. I think it's a terrible disservice for me to treat them differently. And public policy, as Commissioner, I agree that they're probably going to legalize marijuana. And when they do, I will follow the law as the legislature tells me to do, or the Constitution. However, that's where I start getting into some ethical disparities where that's why one of the reasons why I came in, I wanted to make sure there was equality on both sides of these county lines. And that's why I will continue. Right now, to be clear, and you've looked at some of the things staff have given you, the fines, our fine is $100 is what the program costs, which is less than the civil citations around the state. That includes the cost of the program. That's it. We do community service. This board and the city commission have both granted money so that if they can't afford the $100, you all will pay it for them in lieu of additional community service. So it's not a cash register, once again, but I'm going to want to keep, so if you were to set it would, once again, that $100 is generally, I think even Key West is about $100 for their first time marijuana there. So it's basically the same sanction. I'm able to keep fidelity through all 6 counties. And once again, for the legal issues I've talked about earlier, it makes it easier for my law enforcement because I have all of the case law under 893 when that leads to search and seizure, which I don't have any of that, which gets a little bit more in the weeds for an ordinance that you all may create today.
Thank you. Thanks to both of you. Just a quick follow-up question. In our materials, at the bottom of page 12 on the workshop item, The way that it's been written and described here, it's like if we were to have an ordinance, if we were to have a civil penalty for small amounts of marijuana possessions, it's described here as if it would be additive, meaning it would be another tool in your toolbox. But can you help me understand that? Because it doesn't seem to make sense that way. Because if we were, for example, to adopt an ordinance about that, it seems like at least only within Leon County, you would need to apply that civil penalty interpretation to every case, as opposed to being selectively saying, well, in this case of 20 grams or less, we're not going to treat it as a civil penalty, but in this case we are. Can you help me understand that?
You're right. You did into a equal protection argument, a selective prosecution of who are you giving the civil fine to, and candidly, another reality of my world is, and yours as well, is that I have some very affluent FSU students, and then I also represent the poorest zip code in the state of Florida, as do you. And so I wanted to make sure that the possession of marijuana in that poorest zip code was handled the same as it was at Doak Campbell Stadium, which is why I stripped it down to $100, which is the lowest. And then I came to you all, and y'all were gracious enough to set up a situation. If you look at one of the things is mentioned by staff is Pinellas County has a program. I talked to their chief assistant last night. It costs about $1,000. And so if I set that up, that causes me some real concern that once again I get some the Carmen parlance is cash register justice, and I don't want that. I want to make sure that I am equal throughout the circuit and throughout the demographics.
Mr. State Attorney, are you the only person authorized to give programs to set them up? And are we all to genuflect totally to your discretion of Park?
Clearly not.
Is that what you're saying?
No, sir. But I am the person who, I have no choice but to follow the law of the state of Florida. So when I took an oath to follow the Constitution and the law of the state of Florida, I took that very seriously. And so I don't have the power, and candidly the governor and the Supreme Court has repeatedly said that even a state attorney who decides that he's not going to find the law, I can be removed from office. I won't break my oath, and he won't have to remove me.
Right.
So when he tells me in the Florida legislature that marijuana is illegal, I don't get to say I'm not going to follow that one. I have to follow the law of the state of Florida. I agree with Commissioner Welch. I think that the marijuana reform is coming. I think that the legislature could do it. I think it could be by constitutional amendment. But as long as I'm very serious about when I take an oath, and I took one in this courthouse, that I would follow the Constitution and laws. There's no genuflection or anything along those lines. It's just my job I took an oath to enforce the law, and I'm going to do it. I'm using prosecutorial discretion to follow the law and be as lenient as I can. The numbers demonstrate that I'm trying to accomplish the end of means that you all are. But as far as me saying, okay, I'm going to follow Leon County Ordinance ABC and ignore you, Florida legislature, that's not an option for me.
Right. Well, we appreciate that, and I'm getting back to you, Commissioner Minor, and please understand, each of you, that we all have taken that same oath to uphold the laws of Florida and the United States. So our oath is no less JV or junior varsity level than the one that you've taken. Our appreciation for the dexterity and flex that has occurred in the area of marijuana, as pointed out by Commissioner Welch, is simply that we do have commissioners who have taken the same oath, and they have set policies that have allowed and reinforced the values which reflected their communities, to say to their state attorneys that it's the values of this community, which we are elected to civically to represent, that we perceive that 20 grams or less is not. So it's a policy statement that it reinforces. Sheriff McNeil, your prosecutorial thought, and it's a reflection. Now, to the other 5 counties of this second judicial circuit who have not raised it and lifted that up as a priority, we're not at fault for what they don't do. We are accountable for what we do, and it's our effort to arrive at a policy statement with 65, 70,000 college students in particular, my son included among those, and so many other youthful offenders in particular. How do we go on record? And it does not conflict, and we're not here to conflict with your oath, but we are also here to fulfill our own oaths. Commissioner Minor, continue, sir.
Yes, thank you very much. And I'm going to try to wrap up quickly because I know we're running out of
Commissioner Dozier, have you weighed in yet? Okay,
not.
Commissioner Dozier, I'm asking if we shorten and make brief our responses, if we can.
Mr. State Attorney, I definitely heard your comments just a minute ago, as well as what you said in the past, is that you were committed, you took an oath to uphold the laws of the state of Florida. And I think no matter what we do here today, as the chair has just said, I mean, we're not meant to, if we end up doing some type of ordinance, I don't believe that is an affront onto your duties and responsibilities. I think everyone here understands those and understands your high commitment to those. I tend to side with Commissioner Welch in thinking of this, and that this is I think we're seeing a shift, nationally speaking, toward legalization of marijuana, and this might be an opportunity for us to demonstrate that. I support the decriminalization of marijuana. I've got some concerns about how secondary smoke and increased access among our children can affect the development of those young minds. I mean, there's some research that shows that exposure to marijuana for young teens and younger can have permanent effects on their development in terms of memory and retention and that type of thing. So I've got concerns about that. That's not something that is within the scope of today's workshop item, but I think it was very important for us to point that out, because what I'm afraid is going to happen is that while we are legalizing marijuana in this country over the next several years, we may be actually having the pendulum swing too far, exposing many of our children to permanent effects of secondhand smoke and increased access, which 20 years from now we may reset to have some parental controls or controls for those juveniles. But I'm afraid that during that process that we're going to be seeing in this country for the next several years, we may lose some of our kids because of that, because we haven't been judicious enough in making sure that we put proper controls on folks that are under 18. Mr. Chairman, I've got a couple other comments, but in the interest of time, I'll go ahead and wrap up, sir. Thank you very much.
Okay, very good. Commissioner Dozier?
Thank you, Mr. Chair. Just wanted to check in. We got right into discussion, so we have no more presentation. We're going to wrap up discussion and move on. Is that correct, sir?
I think that everyone was prepared to make a longer presentation, but I think that we've read the material. They know the material. So we went beyond the preliminaries because we didn't have to go through that dance. That's why we jumped straight in.
That's just fine, Mr. Chair. I just wanted to get a sense of our time here. Thank you all very much for the hard work on the agenda item. Appreciate the briefing yesterday, Wanda and Andy. And for State Attorney, Sheriff, thank you for joining us today. I guess getting started, and some of you, my colleagues have said this as well, your job is extremely difficult, made more difficult in the last couple of years. We know there's staffing issues. We know there's a lot of other issues. So thank you very much for your leadership and for all of the hard work, and particularly during the pandemic. This has been a challenging time, but you've taken the brunt of it, as have all of our first responders. So thank you for that. And I do want to compliment the incredible work. I mean, Sheriff McNeil, we've spent a lot of time together over the last few months thinking about alternative ways of preventing people from getting into the criminal justice system in the first place. And the diversion programs, the reentry programs, all of these things are really good. I am very concerned about fairness as well. I don't think there's just a double standard here. There's multiple standards across the state, across all of the states, the country. I happen to have been in Colorado for part of spring break, and it is extraordinary, just the difference in walking around and seeing all of the different shops that they have there. But the conversation that people have about the tax revenue, about the benefits to the criminal justice system of legalizing it, that's interesting to hear from the residents out there. And I think, as many of you have said, and you both said as well, we're moving in that direction. And this is not something that Leon County or our region can address or correct. This is something that we need the federal government to step up on. So I want to make that clear. I understand that. Similar to what some of my colleagues have said, though, we have this multidimensional issue here. And we have people that are living in different places with different rules, and they come here and they may not understand that what the rules are in Leon County, particularly for our young people, for our students. And it does set up a really challenging situation where, and I want to point now to the supervised pretrial release reports. I read the one this year, and I read the one, I mean, I read them every year, but specifically the one before the 19 discussion about the ordinance and the one this year. It is interesting to note that cannabis shows up in a lot of the different arrests in the report in 19. The 2021 report, we show more arrests for possession of a controlled substance. Cannabis only shows up a couple of times. And I think what you all said last time this issue came up was that that's really discretion of the arresting officer or deputy on how they make those notations in the report. Is that correct? Okay. So you can cite the numbers for 20 grams or less because you know that in the reports, but for what we receive, it's very general. So I don't know if possession of controlled substance is marijuana or something else, right? But there are a lot of people in that report that don't have other offenses. I mean, I heard what you said, Mr. State Attorney, you're absolutely right. If there's a theft, if there's something else, that's kind of the more minor. You're going to focus on the more extreme crime, and you should, absolutely. But I think those reports, for my purposes, that has been instructive of just kind of looking at what types of arrests and how many people are only charged or arrested for possession or paraphernalia and nothing else. So I guess with that, and this relates to jail population, I'm really glad, as we talked about yesterday, Wanda, that you all have done that review of the jail population, particularly since 17, you went back there. But if someone is arrested for 20 grams or less, and that's the only arrest, it still is a cost to the system. It's a cost to them, it's a cost to their lives, whether they're in a diversion program or not. It's still an impact to their lives. I think we can agree on that. So I do see a little difference here between our next workshop on the detention center population and this issue. So that I appreciate those numbers, but this issue, it still has a cost to lives and to the system when people are arrested. So I'm getting to a couple of questions here, Mr. Chair, but I do want to note that I hear you when you say a lot of the murders that we have, a lot of the shootings involve drug crimes, involve marijuana specifically. Your description of young woman, FAMU student, the cheerleader, is devastating. I'm fairly confident that she didn't think that, instance was going to go that bad, right? It does bring to mind, and this gets into an interesting gray territory because we don't want to promote something. I'm not sure how to address this, but we do have a legal system of medical marijuana. It is high cost. People may not want to get into that system, but based on my understanding of talking to folks and hearing the news over the last few years, you can pretty much get a medical marijuana card for any kind of stated ailment. I mean, there's not really a high bar in the medical, justification for medical marijuana, right? And so if someone doesn't want to get in the system on medical marijuana card or doesn't have the money, that's where the fairness question comes up for me. That's the double standard, that one person can afford that card and they can possess it, and somebody else can't afford it and they can't, and they might be arrested for it. So that's really where I'm focused here. So the questions here, I just would like to hear a few comments about the other 15 counties. I mean, Mr. State Attorney, I know we've seen this differently in the past, and I understand you want fairness among all of the counties you represent. But could you talk a little bit about why, I mean, I assume, from your association or just work with the other state's attorney around Florida, that you may have some understanding of why other state attorneys have chosen to work with law enforcement, work with their counties on an ordinance that has civil citations?
Generally, in those particular jurisdictions, it's single circuit or single county circuits. So you're talking about Tampa, Palm Beach, and their resources are a lot more. In those jurisdictions, the county has, once again, they don't have a problem with fidelity, and they cost, like I said, Pinellas County, it's about $1,000. And so the closest comparison that I have is Alachua. That's when in 2018 we went to the legislature and set up the program. Theirs is 200. I think they may have gone up to 250. But theirs was more. I kept mine cheaper because, candidly, we are poorer. The Second Circuit is generally poorer than the Eighth Circuit, which is Gainesville. But that's generally where I do that. This body can certainly set up programs, and if you're interested in Commissioner Maddox, if y'all want to make a difference in the next meeting, I have lots of ideas of where we can set up programs. And mental health is a big one. The cameras are a big one, and we can talk about that more robustly. But that's in those other counties where they've set that up, they've got diversion programs. They have lots of diversion programs, but the cost is quite a bit more, and the county absorbs that cost, where because I took over the ownership of it, I felt like I had to bear the cost of running the program. If you all want to set up a county, once again, I'm going to ask that you do it for all 6 counties, once again, because of consistency, and that's just going to be a financial, but it's a conversation I'm willing to have. Once again, we can do, I met with Disc Village yesterday, for instance, who runs our diversionary drug court for felonies. So if you got, that's, the felony program is extensive, it's expensive, it's run by the state government. But then it's going to be more skin in the game for y'all as far as money.
Thank you for that. And just to clarify, when you talk about the high cost, this is the diversion programs in general. Or is it specific to the civil citation program for marijuana, 20 grams or less?
The diversion program in general and specific to this, the question comes in, who's going to supervise them? Who's going to do your collections? I do all of that within my office. Other places will subcontract with the clerk of court to handle the financial, or will subcontract, like I could subcontract with your pretrial and probation. That's going to be, but you all are working really hard, and I know they're sitting in this room right now, so before I task them with other things, Pinellas County needs to run through the sheriff's office. So there's other ways to skin a cat, but as often it does, it comes down to a monetary issue. When I came in, it was being outsourced. I wanted to get the fidelity and I wanted to make it cheap. The only way I felt I could ethically do that is to swallow the whole. I always get back to, I'm the only one who has the power to file an information. No, I can't subcontract that. And so if I'm going to be the one making the charging decision, the responsibility ultimately is mine. So that's why it's done. If you want to do that, then I have a referral system where they would go into a civil citation program. It gets to be an ethical issue because if they fail out of that, there's some speedy trial issues that come in. There's also some issues about whether or not the enforcement of a civil contract can be done through criminal penalties. There's a specific rule of ethics that prohibits me doing that. So, for instance, if I put you in a diversion program and you didn't pay your money, and it was referred back to me, I would ostensibly be putting somebody in jail for not paying the county or whatever contract, and that gets to be a pretty good rub ethically where I wouldn't want to be in that position.
Under 7 minutes, commissioners, we need to land this plane.
Thank you, Mr. State Attorney. I appreciate that. This is one of the concerns that I've had about the cost, and I think, for my part, I would like to understand that better in the future. You've given me a good amount of information there, but how a civil citation program might work, where those costs might be allocated or associated, because it seems like there is a cost associated with what's happening right now. And I'm not sure if, which one might be greater. I understand that, I mean, does that make sense that, I mean, we are incurring a cost because we are arresting people now, we're incurring a cost, and you've gotten the cost down for our 6-county region, and that's fantastic. My last question, Mr. Chair, was for the sheriff, so I'll see if he's able to rejoin us in a few minutes.
He's not here right now, so we'll get back to that one.
Yes, sir. So I'll mention this briefly. This was going to be a question for the sheriff. Actually, there you go, sir.
The Sheriff, you had a question, and we're down
pause
to
here for a second.
5 minutes, and I'm asking that we get a chance to receive a motion and give us time to conclude at 10:30.
All right. Thank you. Your comment, Sheriff McNeil, really stood out to me about using our existing pre-arrest diversion programs, civil citation programs more effectively. And the question that State Attorney and I were just discussing was about the cost and how those programs are used, and perhaps the difference between a civil citation for small quantities of marijuana versus the general program of diversion. So with the chair's encouragement here, this is a complicated issue. How would we encourage all of our law enforcement agencies, the universities, TCC, TPD? I know you can only speak for your department, of course, but you work with all of those other agencies. How best can we encourage all of our agencies to use those programs more effectively and more consistently across the board, and specifically for this issue, because there is such a high cost and there's such again, not a double standard, multiple standards throughout the country?
Well, first, I think we have to really realize the nature of the problem we're talking about. I can tell you that probably 80% or thereabouts of all the stuff we're talking about, the crimes, the marijuana use, all of that, are directly related to Tallahassee Police Department's engagement in that arena. And what I believe it requires is our sitting down, myself, Jack, and our police chief, and talking about civil citation utilization as a way of decreasing, from my perspective, if we're effective in terms of getting persons diverted from the criminal justice system, if we're talking about having early interventions with those persons who are using marijuana, my belief is that, and we have to sell this to my colleagues about how that's more effective in terms of directing crime in a different direction. That's an education component, and that's why I said at the outset I take some blame for this, because I really haven't. I'm fighting so many issues of quality of life in our community, but this is one that is high on my agenda at this point, and we've embarked upon at the sheriff's office taking the lead. I certainly can't go to other agencies and start talking about their civil citation non-use when my non-use is perhaps just as high. But my intention is to do an education campaign with our law enforcement partners in our community to see if we can't coalesce around creating more opportunities for civil citations to be issued.
Commissioner Dozier, does that wrap up? Because we're a few moments, and you've definitely gnawed on the last part of this bone, and I want to give the Vice Chair a closing comment.
Mr. Chair, I appreciate that. We've had a good discussion among the six of us, and I'm about done here, but I would like an opportunity to wrap this up because I think this is significant.
Please do. Thank you.
Where might that conversation take place? And Mr. State Attorney, would you be open to that conversation about really encouraging all the other law enforcement entities, our partners throughout the community, to increase the use of the civil citation, and particularly the pre-arrest programs, but also post-arrest, which I know you focus on? There you go.
Thanks. Needed some help to turn the mic on. The sheriff is being kind. He's actually one of the better users. I agree, 80% is TPD. A lot of your state agencies, I think, have mandates that they will not use it. So, you'd have to, once again, get the state of Florida to back up. So am I open to the conversation? Always. That's why if you, in the materials, you saw that every police chief and every sheriff in the Second Circuit signed up when I set up the diversion program, because I love and want continuity. I just texted, I apologize, I got a text message from the sheriff of Franklin County who would like to talk to me, so I'm happy to, and trying to get 6 sheriffs and 25 chiefs together is tough, but I'm willing to have that conversation. We're all trying to make the community safer. I've used what little discretion I have, and have, once again, we now have no one in the jail for the last 3 years for marijuana. 100% of the people who have been arrested for marijuana have been given diversion. I think that I've done as much as I can do. I understand where you all, as a policy, want to be heard, that you think that the community's moving that direction. But as far as being willing to talk, always.
Sheriff
Okay,
O'Neill?
thank you,
Where might
Ms.
that
Vice-
question?
No.
Where might that conversation take place?
Commissioner Dozier, the chair has asked and directed you that we're at 10:30. I'd like for the vice chairman to speak at this time, and I'll open up for a motion.
Mr. Chair, everyone got...
Commissioner, I've been very fair to you and everyone. Can you respect the chair today? If not, if you must have your way, do so. Go right ahead.
Mr. Chair, I'm right at the end here, and everyone got a good amount of time to have their conversation and their
I've
dialogue
said my
about
part.
this.
Talk to whoever you want to. Don't talk to the chair. Talk to whoever you want to talk to at this table now. You're wasting your time talking to me.
This is a critical issue for TPD in the city, and I understand that. I hear you, Sheriff McNeil. I've supported the ordinance in the past, that as the county attorney said right off the top, if we don't have the buy-in from our state attorney and from our law enforcement partners, I am very concerned about passing an ordinance and setting up that, as you all have described, the 3 different charges, the county ordinance, state, and federal. I am concerned about that. I think we need to have some movement on this issue. So, Mr. Vice Chair, if you are going to make the motion, I was going to make it right now, but if you're going to make the motion and the chair would like you to have some closing comments, I would very much like to have some conversation, some dialogue with the city. It could be mayor-chair conversation. It could be through our law enforcement partners. It could be the Commission on the Status of Men and Boys. But some conversation about using the pre-arrest and post-arrest civil citation programs more, and specifically for this issue, because it is so devastating. And we see in the supervised pretrial release that a lot of people are arrested for possession alone and not other crimes. That would be my suggestion. Thank you.
Mr. Vice Chairman, go ahead.
Quickly, I think a couple of things that I heard, and then a very blunt question, straight question to our sheriff and state attorney. We talked about perception and sending a message. I'm not sure that when I took this position, when I ran for election, I thought that I would be up here making decisions strictly based off of creating perception of the community of what we would like to happen. My thought was more aligned of being effective in changing something or preventing a problem that we have or fixing a problem that we have within our community. So I'm a little bit weary on creating an ordinance simply to get a perception to the community of something that, quite frankly, we don't really have the control over. Like Commissioner Cummings and Commissioner Dozier said, there would have to be buy-in from the sheriff and the state attorney for us to move in this direction. The second question I have is two. One, Madam Attorney, can you tell me the difference between an ordinance and a resolution?
An ordinance is something that is legally binding and is on the books. A resolution is an expression of policy. So if you were going to adopt something that you would want to be enforceable, you would want to adopt an ordinance.
What I'll be willing to do here today is to move in the direction of a resolution supporting supporting that the state attorney and the sheriff's office use our diversion program for 20 grams or less. A lot of the conversation got into diversion in its entirety outside of the 20 grams or less. And that's a different conversation. We're talking about 20 grams or less here today. Mr. Chair, the last piece that I'll say is, and this is the blunt question that I had, and I think it helps us all make our decision, is Mr. Attorney, State Attorney, Mr. Sheriff, if today we implemented or went ahead with implementing an ordinance today, would you direct your staff, your sheriffs, your attorneys to enforce that ordinance without discretion?
I could not tell them to enforce without discretion.
Mr. Attorney, you don't have to answer because you've said what you had to say. Given the answer from the sheriff, I will support a resolution. If we want to have more conversation, I think Commissioner Dozier has some good ideas there on diversion as a whole, everybody sitting down and talk about how we do diversion. The state attorney brought up a great idea, and we're talking about 20 grams or less. There's no one incarcerated first time with 20 grams or less, but there's a bunch of people with mental health issues. To sit in the same group and have a conversation around that would be extremely valuable. How do we deal with mental health? What do we do to lessen the jail population when it comes to mental health? And so what I'll do is I'll make a motion. I'll make a motion that we I'll make a motion for a resolution supporting the use of the civil citation program for first-time offenders with 20 grams or less of marijuana. I'll make that motion. And Commissioner Dozier, I'm interested in how you were going to form that meeting piece of it.
Is there a second to this motion? Okay, you have a second. Keep talking.
Commissioner Dozier, I'm interested in how you were going to, because I do think it's a good idea, and I'd like to implement it if I can understand a little bit of how you were going to form that meeting piece of it.
Thank you, Mr. Vice Chair. And just before I get there, option one, accepting the report?
Yes.
Is that part of your motion as well?
Yes.
Okay.
Those are two different points. Those are two divergent points. They can't be in the same motion.
You can accept the report and also
Yes, sir, I can.
create a resolution.
The chair would like to deal with them differently. Okay, I like to deal with the motion that you've made and not necessarily on the receiving of the report.
So be it.
All right.
Okay.
There's any discussion on the motion that has been made?
Mr. Chair, when the Vice Chair asked me a question about the
Go
conversation
ahead.
about
Yeah,
civil
answer.
citations. I think it is a conversation that should happen. Obviously, we're the county commission. We're not going to have Tallahassee Police Department at the table necessarily, but we work together collaboratively. So that's why I don't know if it's the PSCC or Commission on Status of Men and Boys, what the vehicle might be to have a more in-depth conversation about the civil citation, pre-arrest diversion, and post-arrest. Here in the state's attorney, I mean, the program has been working well in the last few years, but my understanding is we don't have as many people going through the pre-arrest or post-arrest. That was based on my briefing yesterday. So again, for time's sake, we could dig into that later. So I'm not sure where that conversation happens, but I think bringing back some information to us on that would be helpful. And it could be at the discretion of the county administrator working with our law enforcement partners on where that conversation might best take place.
So I think, honestly, coming from being a chairman of the PSCC, I believe that conversation would be best had at the PSCC.
That sounds right.
Commissioner Prater is the chairman of the PSCC. We can't tell them what to do. We can ask them to have that conversation around civil citation and how it's implemented, as the sheriff has articulated. So I'll just make the statement that we ask. I don't think it necessarily needs to be a part of the motion, but that we ask the PSCC to have that conversation around civil citation, Mr. Chair. So right now, given the chair's direction, I just want to make the motion for a resolution supporting the use of the civil citation program in first-time standalone offenders of 20 grams or less of marijuana. Keeping an eye, actually ask staff to keep an eye on the numbers. If they inch up, I would expect for us to know that they're inching up so we can have this conversation again. I do trust the state attorney. I trust my sheriff. I've heard what you said. I think very bluntly you said it, that you could not ask your officers to, without discretion, implement or exercise a ordinance that we put together. And I'm not going to put you in that position to have to ask, especially since you're already doing what we've asked you to do in a way of 20 grams or less. So, Mr. Chair, that is my motion.
Very good. All right, I want to thank the Vice Chair for the motion, for the discussion that's been shared on the motion. If a commissioner has a desire that we extend this particular meeting to another round, it certainly has a lot of merits for doing so. The motion has been made. All in favor of Vice Chair's motion, please say aye.
Aye.
Opposed, the same sign. It passes unanimously. Are there any other comments from this commission? We want to thank you all for your presence, for what you've shared, your thoughts, your reflections. It's been a great day. We thank you as we convene now for our next workshop.
Can I just turn around? Yes.
When I say a moment, I mean just a moment. So if the chair would like to continue the meeting, this won't take just a minute.
All right. So, Commissioners,
And
if
at
you
this
take
point-
just a 2-minute break to, if you desire, 2-3-minute break and
You're not staying for this one?
get some coffee.
He's going to get the hot seat, though.
Okay. You got everyone there. I was just here for support.
I'm going to get a seat behind you.
Gentlemen, we thank you for your presence as we get started on this workshop this morning. We'd like to welcome each of you for the time that you've taken. We want to turn now and punt to our county administrator for introduction of matters as we deal with the Leon County Detention Facility population.
Thank you, Mr. Chairman. Commissioners, as you may recall, in October, the board requested a workshop to review the inmate population at the Leon County Detention Facility. The workshop item before you today includes a comprehensive report on historical trends and factors affecting inmate population, a detailed review of all the various strategies that the county and our partners use to review and manage inmate population, as well as options for the board's consideration to identify additional strategies and practices to manage inmate population and to plan proactively for additional space that may be necessary in the future. As you'll hear in today's presentation, Commissioners, Leon County has a very long history of effectively managing jail population, and we use lots of tools available to us to do so. In so doing, Commissioners, we make every effort to use alternatives to incarceration to keep low-level offenders connected to their work and connected to their families, and to use the detention facility to keep the community safe from higher-level offenders. And that's a big part of how we've successfully managed inmate population for nearly 30 years without the need for a costly jail expansion project. But this takes cooperation. It takes a lot of it. That goes to the people that you see around the table here and others, notably members of the PSCC that you referred to earlier in the workshop. Just a few moments ago. And joining us today, Commissioners, for this workshop are several of our partners who are critical to that process. At the table this morning, of course, we're joined again by Sheriff Walt McNeil, who the county delegates the operation of the jail to, and he and his team are highly competent stewards and tremendous partners with us in doing so. Of course, we have Chief Judge Shorstrom with us, our State Attorney Jack Campbell, our Public Defender Jessica Yeary, and you'll hear from all of them in just a moment. Also with me here at the table, Commissioners are Wanda Hunter, Teresa Broxton, Andy Johnson, and Alan Rosenzweig. And we'll start off with a brief presentation, and we got the cue from our last presentation, so it'll be brief. And then we'll turn it over to board interaction with the members that you see around the table. But with that, I'll ask Wanda just to get us started and get the ball rolling. Wanda?
Okay. Thank you, Vince. And Commissioners, as Vince just pointed out, will be very brief. And I know the Chief Judge took time today from a trial to come and be with us. So I mean, out of respect for his time and the time of every other constitutional here, we will quickly get through our presentation. So Commissioners, this morning I just wanted to touch a little bit on some jail population trends, as well as those factors that we know that have impacted the population. We'll talk briefly about some of the alternatives. As Vince mentioned, we have quite a few alternatives that we use to, again, do our best to keep people out of the detention facility, and then wrap up with some recommendations. So I'll get started. Again, we looked at the jail population and the average daily population at the end of the first year the detention facility was fully opened, and looked through 2021, as you can see, recognizing that the jail has a capacity of about 1,219 inmates, not considering classifications of those inmates, meaning felony versus misdemeanor, women, men. In terms of the jail standards, those populations have to be separated. So when we talk about 1,200 bed capacity, it does not take into consideration the separation of those specific populations. And so you can see from that trend line, we've had a few ups and downs over the last 20 years, but the population has generally remained steady. The next slide is just a look at who is in the detention facility by charge. I spoke with Steve Harrelson this morning, and today's current population is 1,127. This snapshot was taken as of March 11th as we were drafting this item. As you can see, the blue line represents the number of felony offenders in the detention facility, and the little orange line represents the number of people who are held on misdemeanor offenses. As we talked about it in our workshop earlier this morning, with the alternatives that are in place, we do our best to try to minimize the number of minor offenders in the detention facility by offering the variety of alternatives to incarceration. The next slide we will look at, as soon as I can get this to work, we'll talk about some of the things that perhaps impact that number you just saw earlier in the detention facility. When starting with the pandemic, and I'm sure you're all aware, just as we had to adjust our business practices and our operations during that 2-year period, so has the courts and the detention facility adjusted their operation. During the height of COVID, jury trials were suspended for about 10 months, and they utilized other resources, just as we did. A lot of our trials and hearings, or mostly plea hearings and things of that nature, were done through Zoom. So those things that required depositions, witnesses, those types of trials, those very detailed, intense court activities were suspended for a period of time. And then after the courts were able to reopen, they reopened at 50% capacity, again, just to ensure the safety of all the people involved. The detention facility itself basically limited the visitation to just essential personnel. So they took extraordinary measures just to make sure that people remained safe that had to be detained, as well as protecting the staff. But what we also saw with those numbers that we just looked at was that there's been an increase in the number of felony offenders, and you saw that over 90% of that population were felons. In fact, 97% of those incarcerated are charged with a felon. In 2019, as we look back, there were only 64 people in the jail charged with murder. By the end of 2021, that number had doubled to over 108%, with 133 people incarcerated. I'm sorry?
The county attorney has indicated to me that the chief judge has a conflict that needs
Okay,
to
you're okay.
wait.
You're okay. I do not want to miss a thing that Wanda says, so go ahead.
When the county attorney is twisting your arm under the table like that,
Yes, sir.
I felt that I needed to.
Yes, sir. I'm
hang on.
sensitive to the judge's time, so I'll be very, very brief. The next piece I wanted to talk about was, again, the length of stay. People who are detained in jail either pre-trial, meaning that they have most have a bond, or there are some who are detained without a bond because it's a risk to public safety. But we saw a 92% increase in since 2019 in terms of the length of stay. At our last review in 2019, it went from 137 days to 263 days, with people being detained in the incarceration. And finally, when we looked at clearance rates, that meaning how quickly a case is disposed, we saw that prior to the pandemic, the court clearance rates, or the case clearance rates, were on par with the state. And everyone throughout the state suffered in terms, I think at one small point in time, it was about 50% case closure rates, because again, the courts were not fully operational. And the county, Leon County, because we took extraordinary measures to ensure safety, we dropped below the state average for a couple of quarters within that time frame, and I think the chief judge will speak a little bit more on that. But however, and so that resulted in a bottleneck of people being detained in the detention facility. But since we fully reopened the community as well as the courts, we are back on par with the state average in terms of case closures. As the county administrator mentioned earlier, and he reminds me, let's go to the next slide, that we have a myriad of alternatives in place to address incarceration. And as he spoke to me the other day, reminded me that one of our first alternatives is to have alternatives first. And we have quite a few alternatives, beginning, and some are very new alternatives. Some have been in existence for quite some time. So I'll briefly run through a few of them. For example, some proactive measures that we take to ensure that people never have contact with the criminal justice system. The crisis intervention team training has been around for more than a decade, where law enforcement and other professionals, such as the supervised pretrial release staff and other court officials, I will say, are trained in how to engage with people they may encounter that are in crisis. Again, this is a tool that is used by law enforcement that, when possible, they will have someone with mental health CIT training on the scene to ensure that they are diffusing the situation and, if possible, diverting that person to resources within the community in lieu of jail. There are multiple mental health response teams, beginning with the Appalachia Center. You may recall that after the Marjory Stoneman Douglas shootings in South Florida, the state granted funds to our local receiving facility, Appalachia Center, to house a mental health response team to be responsive to youth who may be in crisis or having difficulty. In that program, they can reach out directly to Appalachia Center, and they will respond directly to families or may assist law enforcement in calls. During last year's budget process, you also funded a mental health response team for the sheriff's office and provided them with funding to have a mental health professional ride along with law enforcement, again, as an option to sort of diffuse issues before people are having contact with law enforcement. You just recently funded the homeless outreach team, which is we call the host team, that is, again, responsible for engaging with those, the homeless community, and trying to address those issues and helping them find stable housing before issues escalate and they may be contacting the criminal justice system. Most recently, this board funded the Council on the Status of Men and Boys and provided funding to, again, try to address a very vulnerable population of young men. You will see with that number that we just showed you with people incarcerated, they are between the primary population is between the ages of 18 and 29. The Sheriff's Council on the Status of Men and Boys is, again, put in place to divert young men and boys and giving them some alternatives to help, again, defer them from the criminal justice system. You heard a little bit about some of our pre and post arrest diversion tools. In our earlier workshop, the state attorney operates an adult pre-arrest diversion program as well as a post-arrest diversion program. And there's a juvenile arrest diversion program that's also in place. The courts have at their disposal to divert people from incarceration is releasing people on their own recognizance with the understanding that they would appear in court. They also use bond as a measure. And then Teresa will speak briefly about the supervised pretrial release program and the other tools that we have available under the Office of Intervention and Detention Alternatives. Not only do we have pretrial release where people are diverted after arrest to be monitored in the community, and as the county administrator said, they maintain their jobs and their families and their households. Again, we try to defer as many people as possible. The board funded probably about a decade ago, a position called the Detention Review Coordinator. And that person's only job is to constantly look at the detention facility population and determine who can be released immediately, regardless of whether they have bonds. And primarily there are some who are detained who have not been able to pay bonds. The Detention Review Coordinator will look at those cases specifically, as well as some of those who are nearing trial or that might be available for immediate pleas and get them out of the detention facility. Again, we were going to talk briefly about the specialty course of felony drug court, which is another diversion tool that's used by the state attorney as well as defense counsel to help those people who have been known to have chronic issues with substance abuse and, again, defer them from the criminal justice system by putting them through a one-year program that includes counseling as well as regular drug testing and individual counseling, group counseling to kind of get to the root cause of what may be causing them to continually find themselves in the criminal justice system. There's also Veterans Treatment Court that, again, is a specialty court specifically to help veterans with their special issues and defer them from incarceration. And I think most of you are familiar with what post-arrest county probation and state probation does. In fact, Ms. Broxton operates our county probation program. And under that umbrella, along with supervised pretrial release county probation, there's also alcohol monitoring and as well as electronic monitoring, both passive and active GPS, where you can have real-time monitoring, or passive monitoring, where the information is detained, where defendants are released from incarceration, but they are required to wear an ankle bracelet to ensure that they have no contact with certain areas or people that the court have determined that they should stay away from. In terms of programs that are in place to prevent recidivism, there, again, are a number of programs that the sheriff's offers within the detention facility from the time that they are arrested and booked into the detention facility. The process starts with classification, where it's determined whether or not certain skills training would be helpful for them to, again, find gainful employment and stay away from arrest in the future. The other programs are, again, programs intended to prevent recidivism. You see below is the Sheriff's Reentry Innovation Services and Empowerment Center. The board supported that program last year, and it serves as a sort of clearinghouse for those who are returning to the community from either state prison or from our local detention facility to help them gain skills and learn, get information about how to reestablish themselves in the community. It does everything from helping them reestablish their identity through driver's license and ID cards, as well as information that will help them with finding employment and even housing. I wanted to briefly mention the Refire Culinary Program, and some of you may be familiar with it. It is one of the community's premier programs for helping people find employment and gain employment skills after they return to the community. The director of that program, Ms. Rebecca Kelly Manders, serves as the vice chair of the Public Safety Coordinating Council and is very instrumental in helping people gain skills in the hospitality industry and the food service industry to get employment, and has experienced a very successful program with 93% of her participants successfully have found employment. And again, those are just the general things I wanted to hit on, commissioners. The next piece I wanted to give Ms. Broxton an opportunity to. Okay, I think before we cut over to Ms. Broxton, we will recognize Chief Judge Shustrom.
Thank you. So,
our chamber this morning, you taking time from your exceptionally busy schedule. The crux of the issue at this population management discussion this morning, I think Wanda's identified it. 2019, we were at an average stay of 137 days. As of March of this year, the average stay is at 264. The persons missing here, I believe 86% of all the arrests in this community come from TPD. They're not at the table, and possibly as city commissioners don't feel the angst of a creep that goes from 137 to 264. So this commission today is burdened by, we're stressed and anxiety filled with this quantum leap. And we welcome you to share with us the tools that have been outlined, presented to us in writing, your sense of the landscape of how do we get ourselves back to where we were pre-pandemic, sir. Thank you so much, and we welcome your comments.
thank you, Chair. It's a privilege to be heard. I thank you so much for your attention to this important issue. I can't tell you that I know the answer to why stays in the jail have gotten more lengthy specifically. I suspect that number has something to do with the pandemic, and I suspect that number has something to do with the increase in the number of extraordinarily serious accusations that remain pending and unresolved. My experience in the criminal justice system as a judge handling felony, I handle general jurisdiction in Franklin County now, which is a fairly busy felony docket as well. People who tend to stay the longest are the people for whom the stakes are the highest. And so I suspect that when Ms. Hunter tells us that the number of people in custody accused of homicides has doubled, that explains to some extent the increase in length of time, average length of time that people are staying in custody. I don't know the answer to your question more than my general judgment, though. What I would ask is that I'll ask my staff to look into it and consider it, because I don't know more than the reaction that I'm having. So one thing I want to say is, and y'all heard me say this the last time, is how proud I am of the advocates that we have, how proud I am of the judges, my colleagues, how proud I am of the people that work in criminal justice. The stakes are extraordinarily high. The cause of people who are accused, the cause of people who have been victimized is just it's as important as anything that we do in the court system. If you look on the chart, you'll see a downward spike that happened at the beginning of the pandemic. And the reason for that spike is because the Sheriff's Department approached the State Attorney's Office, Public Defender's Office, and said, we got a problem. We are having a global pandemic, and we've got to have some way to deal with people who have been exposed, people who are positive, and people who are not positive, to try and have isolation. And we moved heaven and earth to do that. Moving heaven and earth is not a sustainable policy, in my judgment. We can do things at the margin. I think we have done things at the margin. The problem with moving heaven and earth is that the problems of the community continue. The problems that lead to arrest and incarceration continue. The policies that we have, the statutes that we have that constrain us. Judges are neutrals. Judges are responsible to afford all litigants due process of law. And one of the bedrock fundamental principles of due process of law is the independence of the judiciary, the independence of each individual judge responsible for the case of a human being and making the best judgments that the law permits and the evidence will support. Evidence in the broad sense, not evidence in the trial sense, because many of the decisions that are made from the beginning, from arrest and first appearance through bond decisions, through pretrial release, through sentencing, if there's going to be a sentencing, is not based on evidence that's submitted at trial. It's based on a probable cause standard. And so judges have to make those individual decisions in an individual case. When we moved heaven and earth, we moved some of that individual discretion away from the judges in deference to the needs the Sheriff's Department absolutely had to ensure the ability of the sheriff to isolate people in deference to the pandemic. We were briefly closed, 10 months, I guess we were closed. And then we opened up partially, and since the fall of last year, we've been open for trial. There's another group of people that I want to express that all of us who do this work should be humbled by. All of you who make policy for us should be humbled by, and that is your fellow citizens. Both our public defender, I believe, and our state attorney have both said nothing resolves cases like jurors in the building. And there's it couldn't be more true. Since the pandemic, since we reopened, 7,558 of our fellow citizens have answered that call. We have never a single time been unable to convene a case and resolve a case because jurors didn't answer the call. They did. And because of that, we are putting the backlog, I hope, in the rearview mirror. We are open for business. Nobody should be unable to get a trial because of a lack of our capacity, and that has not been my experience. We've conducted we've seated more than 200 juries, tried more than 150 cases to verdict, and that's the best long-term solution to our problem, is giving people the opportunity to resolve their cases timely. And we're no longer operating under any COVID restrictions. Ms. Hunter, and I'm sorry I called you by your first name earlier. I was just reading an article about sexism this morning, and I thought to myself, if anybody deserves the respect to be called by her full name and title, it's Ms. Hunter. So please accept my apology for that. In this forum, you should be treated respectfully. And what you've just described of everything that the county does, that we do, that the state attorney's office does, the sheriff's department, public defender's office, private counsel does to try to have incarceration alternatives. I'd forgotten about that. Kendra Brown, crisis intervention, team training. How many hundreds of law enforcement officers have we trained in diverting people from criminal justice to mental health? How many? Over 900 law enforcement officers, a week of training. Many law enforcement officers will tell us it is the most training that they get after the academy. It is an important question that you're asking, which is, what should our jail population be? What should we do to control it? What is the appropriate response to the data and the challenges that the sheriff is facing in running a jail? The judges stand ready to resolve cases. We are open for business. We look forward to your leadership, and our resources are at your disposal. Thank you so much for this opportunity. I'm going to send Judge Allman, who's our administrative judge of felony, up to tag out, and he'll be available to answer any questions. He has the benefit of doing the work in Leon County.
Mr. Chief Judge, before you go, I know it's inappropriate to ask Attorney Cummings would know you can't ask the Chief Judge questions. But it was suggested, and perhaps comments have been made, that maybe if we went to a 16-hour court, that it could unload and unlock the bottleneck. And I just wanted to put it out there. That's not a question. I'm just saying what I heard. And
16-hour court.
16-hour, for our judges to really get busy. And
I think I'm going to go out on a limb and say I'm opposed to it.
I was trying to help out,
I appreciate you so much, Chairman Proctor. It's a privilege to be heard. If there's nothing else, I'm going to go get Judge Allman.
Okay, thank you so kindly.
Thank you very much.
Appreciate it. All right, Ms. Hunter, I want to make sure, Ms. Hunter.
Thank you, Commissioner. And so, again, I just sort of ran over briefly the programs that we have in place now that serve as alternatives to incarceration. And you'll hear later from our staff member, Andy Johnson, that we might consider looking at if there are other programs out there that might be available to us that we could consider implementing. I know the state attorney mentioned earlier that he had some ideas. But again, as the county administrator reminds me, Wanda, Our first alternative is to have alternatives first. So we are constantly looking for programs that would support managing that jail population. And I was remiss in not mentioning the good work of the Public Safety Coordinating Council, which Chairman Proctor chairs. And just speaking briefly to their work with programs that they put in place in the past, they offered a program that was designed to provide employability skills for inmates that was called the Leveraging Interventions for Transformations, all these acronyms. So it was called the LIFT program, Leveraging Interventions for Transformations, that we ran that program for about 10 years. Recently, the board approved the PSCC's request to utilize those funds that you provide to them to help manage the jail population to put in place a landlord mitigation trust fund, again, to help house those populations returning to the community who were at times difficult to find safe and affordable housing. So those funds are being used for that purpose. But I wanted to take a minute now to move on to Ms. Broxson to allow her to speak briefly on how COVID has impacted the operations in the probation and supervised pretrial release programs.
Thank you, Wanda. Good morning, Commissioners. As Wanda shared, the Office of Intervention and Detention Alternatives consists of the supervised pretrial release, probation, and drug and alcohol testing divisions, which provide pretrial and post-sentence alternatives to incarceration through community supervision. You've heard a couple of scenarios this morning where the impact to the pretrial release program increased utilization significantly. The first was in 2019. The chief judge, who was just here, issued 2 administrative orders governing the pretrial release program and the first appearance process. Those orders were designed to ensure that each defendant receives an individualized assessment of their ability to be released from the detention facility without monetary bond, and also, in addition, making sure any conditions of release that would enhance public safety were implemented. This was the first significant increase in the pretrial release population. Following that, as with every other area of the world, the criminal justice system was impacted by COVID. And as the criminal justice system had to alter their operations for public safety and suspended court operations as virtual alternatives were implemented, we saw our partners around the table work to get people out of the detention facility. That increased the pretrial release program yet again. And so we had 2 significant events increasing our population. As the pretrial release program continued to be an effective alternative to incarceration, we continue to see those numbers increase over the past 3 years. During when the courts began to reopen and cases were being disposed, we had more cases that were sentenced to county probation. And as a result, both pretrial and probation case numbers increased by 23%. And we now have more than 1,600 people in the community on supervision that are not in the detention facility. In just a moment, Andy will be sharing the recommendations throughout the item. I did, however, want to just touch on one, which was the addition of 2 new pretrial probation officer positions that would help us to maintain effective case management ratios as the numbers continue to increase.
Could you touch on for the commission the electronic monitoring element as well?
Certainly. Leon County offers electronic monitoring, GPS, which is location tracking, and as well as SCRAM, which is alcohol detection. We routinely have, or on average, have 200 individuals who are being supervised by electronic monitoring on any given day.
Okay, very good. Okay, Andy.
Thank you, Teresa. Good morning, Mr. Chairman, Commissioners. In addition to the recommendation in your item that Teresa just talked about, your workshop materials also include 2 additional options for managing the inmate population at the detention facility that the board may wish to consider. And these are options number 3 and number 4 in your workshop item, and I'll talk about them both briefly on this slide. First, Commissioners, option number 3 in your workshop item seeks the board's consideration to retain consultant services to identify any additional strategies for managing the inmate population, as well as to evaluate any additional space needs at the detention facility that may be needed in the future. Should the board wish to approve this option, that would direct staff to include funding in the upcoming budget cycle for those services. As it's laid out in your workshop materials, Commissioners, the scope of work would include two things. First, reviewing any additional programs, strategies, and best practices for managing the detention facility population that could potentially be implemented here in Leon County. As the county administrator and Ms. Hunter discussed earlier, obviously the county has a long history of effectively managing the inmate population, but this effort, as it's included in your item, would basically make sure that we've left absolutely no stone unturned, and also, frankly, to do an updated review of any emerging best practices in this area throughout the state and country. And the second item that would be included in the scope of work, Commissioners, would be to analyze trends in the inmate population, the composition of the inmate population. As Ms. Hunter mentioned earlier, certain subsets of the inmate population have to be housed separately, et cetera. So based on that analysis, the consultant services identified in your item would be used to project any additional space that may be needed at the detention facility in the future. And should that study identify additional long-term space needs, it would allow us, of course, to develop accurate cost estimates and budget predictably to address those needs as they may arise in future years. And finally, Commissioners, the last option in your workshop item, which is option number 4, seeks the board's consideration to develop a policy proposal regarding pretrial felony inmates in partnership with the Florida Association of Counties for next year's legislative session. As you may recall, Commissioners, FACT's policy development process occurs over the summertime, so that's why we are bringing this option to the board now for your consideration, as opposed to during our legislative priorities workshop, which we host annually each fall. Just briefly, Commissioners, there's an important distinction, and we've discussed this at length in your workshop item, between the role of county jails and state and federal prison facilities. Generally speaking, county jails are designed to house lower level offenders for a shorter period of time, generally less than 1-year sentences. On the other hand, prisons, of course, are more focused on long-term housing and rehabilitation, particularly for more serious and often violent offenders. As you've heard this morning, the county and our partners, of course, have put in place a number of different programs over the years to provide intervention strategies and diversion opportunities at every point throughout the criminal justice process. But due to the factors that Ms. Hunter discussed earlier, as you know, we have a growing number of felony offenders that are housed in our county detention facility, many of whom are awaiting trial and sentencing, some for 2 years, 3 years, or upwards. And frankly, this is not a situation that's unique to Leon County. We've reached out to our partners at FAC as well as the National Association of Counties, and there are many counties throughout the state and throughout the country that are experiencing similar trends with their detention facilities. So as a result, Commissioners, the option in your workshop materials would be to direct us to develop a policy proposal in coordination with FAC that would place a limit on the amount of time that felony offenders awaiting trial could be housed in a county jail before being transferred into state custody. And I'll just say very briefly that we acknowledge that that would be a very big conversation. There would be a lot of considerations that would have to be discussed. But by working with FAC on that issue, that would enable us to really bring together all the stakeholders involved in this statewide, including law enforcement, courts, public defenders, state attorneys, and frankly the Florida Department of Corrections as well, to really initiate a conversation on what that looks like and if there is a feasible path forward to basically, at the end of the day, lessen the burden on county detention facilities for housing felony offenders for an extended period of time. And if the board would like to provide that direction, again, that's option number 4, we would bring you back a draft policy proposal later this spring or early summer, and that would give you time to consider it and approve it prior to FAC's policy development process over the summertime. And Commissioners, with that concludes our portion of the presentation. As you see here on the slide, the workshop item recommends option number 1 through 4. Mr. Chairman, with that, we're happy to answer any questions you may have or hand it over to our partners around the table for their remarks.
Vice Chairman Maddox desires to speak, but before he does, I want to just ask in general, because I don't know, are there reasons that we should be ashamed of the Leon County Detention Center Are there bases of which specifically of these items that we have needs, or how do we rank compared to other facilities, or how do you rank detention facilities? And, I know if you need a new suit for Easter, sometimes your children's suits, the pants get short, sleeves get short. But how do you know, does your pants get short, your sleeves get short at the jail? What do you go by? These are strong recommendations.
Mr. Chairman, I'll take that. I believe the sheriff would agree that his is the very best that there is. There's no place you'd rather be.
I thought we had
that may not be
you know what I mean?
exactly true, but no, obviously what you've heard here today is, again, just a glimpse of all that goes into jail population management, which has to be actively managed. Jail populations don't manage themselves, and you'll see from all of the lists of programs that we have in place that we're doing just that. You may go to other counties and find, just for comparative purposes, Commissioner, I've done this, speaking with other counties where they have 2 or 3 or 4 of the programs that you saw in place, but in many cases, not 12 and 13 and 14. It's just, and you saw just in the review today, 3 or 4 that you've just added relatively recently to deal with certain populations and that sort of thing. And that comes down to the cooperation that we have with all the partners around the table. And so what you've heard here today is, yes, even though our jail population is reaching capacity, and in many cases is at capacity, especially with the way that the state measures that, what you've heard in terms of what we're doing as we come out of COVID, what you're hearing in terms of the additional pretrial positions, what we're doing at the legislative front, and what we intend to do prospectively as we continue to evaluate opportunities. Again, we think we're in as good a shape as we can be in, and we're doing these things proactively so that, frankly, nothing sneaks up on us, whether that's additional jail space or any of those issues. We're all working proactively together so that the best that we can, that we have no surprises, and we continue to manage as effectively as we can. But with that, Mr. Chairman, I know those around the table are happy to answer any questions that you might have, and I see the sheriff leaning in here as well.
Sheriff, you
I think I'm
having reflections on that question. This commission wants to know, how do we rate, are we to rank ourselves or see ourselves relative to standards for detention facilities?
Mr. Chair and Commissioners, first of all, let me say to the entire staff who's here, we often think of the Leon County Sheriff's Office as, perhaps you don't, but the community does, as an entity in and of itself that's out there on Appleyard Drive. The fact of the matter is that your staff here does a tremendous job of assisting us in how we look forward to and how we anticipate issues and deal with issues related to jail population and the jail itself. Having said that, I believe that our detention facility is one of the best in the state. Now, it is not, and the caveat is it was never built with the anticipation of being a jail per se. It was built as a detention facility, which meant it was built to hold people for a shorter period of time. But with respect to your question, we are an accredited detention facility. We are inspected on a regular basis as to our policies, our procedures, and the quality of our treatment of the inmates that are there. And I can tell you that we stand and we go and we compare ourselves to Alachua and other similarly situated detention facilities, and we believe that we're one of the best in the state, notwithstanding perhaps the country. But that does not mean, I think the things I see here on the agenda today indicate that your staff and our staffs are looking forward to how we continue to be at that place and even get better.
We received that coming from the former Secretary of Corrections, Mr. Vice Chairman.
Thank you, Mr. Chair. 1, 2, and 4, I'm quite fine with. Number 3, I'm seeking to understand a little bit. So, are we at the level that we need a consultant to come in? Do we not have the expertise in the house to be able to make those kind of decisions or make those kind of determinations and get that information back to the board, Mr. Administrator?
Was that a motion or inquiry?
It's an inquiry for right now.
Very good.
No, I think the recommendation reflects the fact that we need to do a look beyond the technical staff that we have in place, and to really evaluate ourselves compared to other facilities and that sort of thing. So yeah, this would be a recommendation that we have that we would think would be important again for us to look at again, so that we're anticipating the future needs. I mean, granted, and Wanda said it a lot today about alternatives first, but we also recognize, again, frankly, that a potential jail expansion project, whenever that was to happen, is a big, costly initiative that needs to be planned for years in advance. And so it is something that it's not first and foremost that we're going to engage a consultant to say, hey, this is a process for you to go figure out where we can and need to expand. It would first and foremost be to evaluate what we currently have and how we're utilizing what we currently have and that sort of thing. But it would include, again, help us plan for these types of potential needs prospectively.
Mr. Administrator, how long will a consultant study be relevant after it's done?
It's not like an engineering report that would expire at a certain period of time. We would all have to look at it, look at the findings of it. We would all help in scoping it so that we could make sure that we get maximum use out of it over a long period of time.
Mr. Sheriff, I hadn't heard you request a new detention facility, and as you said, you thought the one we have is pretty good, but we need to keep up with the changing times. I would imagine as we've seen sports facilities at college level try to keep up with each other. FSU just built a new locker room. I would imagine that we want to keep up technology-wise and jail-wise with the trends and what's going on, what we need. Is that kind of, though you haven't requested, is that the way you see it and are looking at potentially doing some renovations or building onto the jail as trying to keep up with what the trends are, what the needs are for the jail?
Commissioner, my assessment upon becoming sheriff of Leon County was to go into our detention facility, look at where we are, look at our population, look at our delivery system, the programs we have, and from that initial review, I concluded that one, we needed additional programming, and we've done that.
Right.
And the second thing, and I have had these conversations with staff, which is we do need to be proactive in terms of right now we are on the cusp of being at capacity. And if the trends continue in our community as they are, it's anticipated that we will, in fact, get to a point where we are overcrowded. Right. Rather than get to that point, what I've shared with staff is we have to be real proactive in looking at these things and planning for if that is, in fact, the direction this community continues to go in. We are growing, and with that growth, you can expect that you're going to still have growth in crime. And if we continue the way we are currently, then obviously the place we'd like to be is not where we'll have an overcrowding situation.
Thank you. Is there a standard there, Mr. Administrator, Mr. Sheriff, who would know? Is there a standard there of sales per population, meaning, okay, so we're at 300,000 people, our jail should be this size, or is there any kind of standard there? Are we comparable to like-sized counties as far as population, as far as the population or the max population of the jail is concerned, or detention center?
Commissioner, we do have a thing called Florida Model Jail Standards, which dictate how much space has to be given to each inmate.
Yes, sir. Or
how much per two. We are at that right now. We are evaluated by Florida Model Jail Standards every year.
Right.
And we pass that an assessment every year. They set the standard for us right now. So our space is limited to 1219. Now that is if you throw everything out, classification, PREA requirements or anything like that, we're just housing bodies at that point.
Right.
We can't do that. When the sheriff said we're at the cusp, we are. We've been at the cusp. There was the Institute for Law Enforcement and Policy Planning that did a study back in 1988 on the detention facility at the time, the old one, that we had overcrowding reports before then. Back then, they suggested building a facility at 1,214 capacity with the ability to expand to 3,000. That was in 1988. They recommended when you reach 80% capacity or more, that's when you start planning for additional space. We've been at 80% since 1997, except for maybe 1 or 2 years we dipped right below it. But 80% on 1,219 is 975 bodies.
Thank you. So look, here's where I'll go ahead and make the motion for items. I'm convinced on 3. So I'll go ahead and make the item for 1 through 4. I think 3 is more about us being proactive, as you spoke of, and more so than us doing anything else. I'm very, very worried about creating a perception that we are building a jail to lock up more people. You know, that's when you talk about increasing size, that's a perception that goes out there. We just talked about perception and messages. I would like for us to really send a message that we're doing everything we can to lower the population, so we are below that 80%, so we don't have to consider much in the way of building additional cells. Now, renovations to make it, you know, meet standards as far as technology and things like that, okay, I'm all over that. But when we talk about building on to the jail, it means we have a space issue. It means we need more cells for more people. I would like for us to, and I know we're already doing this, Mr. Sheriff and your staff, I know you, because you just talked about a second ago in this directive. How do we get below that 80% without building on? What's that look like? What do those diversion programs look like? If we have exhausted all possibilities to do that, then we have no other choice than to build on to accommodate for that 80%, being at 80% or below. That's the kind of conversation or way to frame the conversation the way I would like for it to be framed. So I'll go ahead and make the motion for options 1 through 4 with the caveat that I want us to look at every single option we can before we even consider a building onto the jail. Also, the reason I asked the question about population is because I was wondering, you know, if you got 300,000 people, you know, how many people did we have in 1987 in Leon County versus now? Is there a correlation there between having 300,000 people and, I think you said what, 1219? 1219 cells? Should we be at, you know, 1,500 or 1,400 cells because we've got now 300,000 people? So what does that correlation look like, if there is any? I know that the standard is not based off of that. The standard is based off of 80%. But to me, it means if you got, you know, 125,000 people, but your jail's at 80% and you got 1,000 cells, even though you have considerably less than we have in Leon County, the standard is you still need more cells because you're at 80%. Am I perceiving that correctly?
Mr. Commissioner, the issue is not a simple one. It's a really complex issue. But the main thing that I think we can take away from these discussions is that if you look back in time, you will find that most of our persons incarcerated in our detention facility were there for a shorter period of time based on misdemeanor level crimes. What we have today are more of our inmates are there for a much longer period of time. Right. That's why I make the comment that if that is the standard that's going to exist in our community, that we are, as the Chief Judge talked about it, he talked about judges judging cases, prosecutors prosecuting. Everybody has their lane. And if in Leon County, if we're going to have more persons, as somebody indicated here today, that it behooves the client that's incarcerated to stay in longer. The longer you're in, the more likelihood you are for time to pass where you forget all the facts about the case, or it puts you in a better case to represent your client. That's the reality of the condition we're in, which makes people stay in our detention facility much longer. And if that's going to be the environment we're in, whether we want to build another addition on or not, right. I am not going to, as the person you've asked to do this, I do not want to be in a position where I have an overcrowded detention facility. And the way we alleviate that, since I can't control what the judicial does on either side of the equation, I have to deal with the reality of the situation, and so do you, of the types of persons we have incarcerated. And if we're having people stay now, over 150, 200 people who are incarcerated, waiting for trial or waiting to go to trial or waiting to go to the state prison, if that's our reality, then that's the clients that we receive. And we have to deal with those realities from our perspective.
Thank you. Wrapping up, Mr. Chair, I have no desire to make our jails, our detention centers into prisons. That's just not where I am. And as I understand it, you're in detention center a year or less. Anything over that, then you're going to prison. I have no intention on doing that. And so I'm glad you framed it more as a policy issue and time spent there than you did population. You gave me an education there. So I think you guys understand where I am on it. Options 1 through 4, with the caveat that I'm really interested in us lowering the population to that 80, with that threshold of 80% or less.
Commissioner Welch, this conversation is rich, and we appreciate your comments, Mr. Vice Chairman.
I made a motion.
The motion,
second
I'm
it.
sorry. Is there a second to the motion?
I'll second it.
Commissioner Welch, and comments by Commissioner Welch, followed by Commissioner Cummings and Dozier and Minor.
Thank you, Mr. Chair. I'll second the Vice Chair's motion.
Excuse me, Commissioner Welch, before you
Sure.
get started, I want to recognize Judge Frank Allman, who's been sitting there. Judge Allman, we welcome you here to our meeting. We also want to recognize the presence of the PSCC member, Mr. Mack, who's here and has been here all morning with us. And I also want to recognize Attorney, the State Attorney's Office, Mr. McCall. Mr. McCall, I want to thank Mr. McCall. And we get to gnaw on this bone in the PSCC frequently, and this is kind of like sitting in a PSCC meeting for them. So we thank them for their presence. Okay, Commissioner.
Thank you, Mr. Chair. I'll be brief. Thank you all, everybody that's here that's interested in this subject matter. I am too interested in it. As you know, Mr. Sheriff, I came out and toured the jail, and I like what you touched on to admit the Vice Chair's commentary. I think you say standards. I think that sort of correlates to reality, right? We have a reality. And that reality is dynamic. The situation in the jail is dynamic. There's all kinds of factors that play into populations, how long people are there. I think if we want to simplify the jail population, we can simplify it to that point, which is what's the reality of the situation? I mean, we have to accept, to your earlier point, that Leon County is growing. And we talk about growth in this chamber a lot, and we're going to have comp plan amendments later on in the day, and we talk about where are we going to facilitate growth, how are we going to accept growth. Well, growth, the jail population you would have to expect is going to grow as a percentage of the larger population growing, right? So as Leon County builds more houses, because we need more houses, we're going to need more beds in the jail. I think that's just a reality. And I think also as Leon County's dynamics change, you're going to see different types of crime. As to your point again, you're going to see more violent crime, and violent criminals are going to be in jail longer. The dynamics of the criminal justice system are such that they're trying to work out the best deal they can to avoid going to the big prisons at the state level. So my question to you really centers around this notion that would you correlate population in the jail with services? Like, is it a better experience with a lower population in the jail? My presumption would be that it is. It's better for the guards. It's better for corrections deputies. It's better for the sheriff. It's better for the community probably if the population is lower and or the space available is there's more vacancy available. So I think when we talk about that, I can support the 4 options. I think it's a 2-pronged approach. Obviously, we want to eliminate people going to the jail to the extent that we can with diversions. But at the same time, I think we do, Mr. County Administrator, we all need to start kind of accepting the notion that we're going to have to build more space at the jail, at the detention facility. And so I think that as a community, we have to accept that because we're growing. and that space is going to be needed. We can do everything we can in the world to divert folks from the jail, but if you murder somebody, you're going to spend time in the detention facility, and it could be a prolonged amount of time. We have 130 people in the detention facility right now that are accused of murder or capital crimes. So, again, I grew up somewhere where that was prevalent, and you have to, you want to accept that your community is going to be a haven for violent crime, and you see all those programs that we have to try and prevent that, and the Commission on the Status of Men and Boys is hopefully going to mitigate that to some extent. But as your community changes, I think you have to at some point accept that you're going to have to, in order to make your detention facility experience a better one, to get to those numbers, 80% capacities or whatever the standard recommendations are, you're going to have to think about that. And I know the county administrator does, and they're good at, and Alan, and we're, and you know this, Mr. Sheriff, we're good at projecting out needs and what was it, have options first have options or whatever, alternatives. So I just want to let you know that I recognize that reality that you guys are dealing with. And all of us as policymakers and leaders in the community, I think, embrace that reality. We want to do everything we can to mitigate it, but we also have to accept that that is the reality. So I'll support those 4 options. I think those are well thought out by the staff, and I know you guys are doing a good job, and I just want to take that opportunity again to commend all of our detention facility staff and our deputies, because that's a tough gig. And I acknowledge that when we toured it, that's a tough gig, 12-hour shifts, right? 1 or 2 breaks for staff in that 12-hour, 30-minute breaks, if they can get them, right? So I want to see us do everything we can to mitigate the negative experiences in our detention facility, and I think that will trickle down not just from residents, but also to staff who work there every day. Thank you.
I forgot the order. If you recall, please follow it. Who's next? Good.
Thank you, Mr. Chair. I just want to make a couple of general comments and maybe ask a couple of questions on the options. But I certainly recognize the complexity of the criminal justice system. Everybody has its role, and I think our sheriff is doing a tremendous job. Our state attorney does a tremendous job. Jessica Early, our public defender, does a tremendous job. And everybody in his own role is what makes the system work. I appreciate Ms. Hunter, clearly, Vince Long, and all the staff that work so hard every day to do what we can to protect the citizens in Leon County.
Commissioner Cummings, you want
Yes,
to
sir.
call Ms. Hunter Miss Hunter and call Vince Long just Vince Long. You want to do that?
Our county administrator, Vincent Long.
We had a strong precedent established when the chief judge said Miss Hunter.
Mr. Johnson, and I can't remember her name. But anyway, everybody has done a tremendous job on a daily basis. And this is an excellent report. It's given us the raw numbers, and I just appreciate everybody working together to bring that to us. But back to my point, it's complicated. We are here looking at the jail population and what we can do from a policy standpoint in conjunction with our law enforcement people that we have elected. And so I believe that more roundtables like this are clearly necessary. Within the last, I guess, couple of months, I was at a roundtable with the state attorney, the public defender, community leaders, the sheriff was there, and the faith-based community, just trying to brainstorm to see what we could do to lessen the population in the jail. And so my first question is, somebody in that forum mentioned involving community-based organizations and some faith-based organizations as conduits, trustees, so to speak, as it relates to some of the inmates, maybe not necessarily those charged with felonies. But my question is, have we ever utilized or considered utilizing or deputizing some of those entities or groups, and do we believe that they could be effective in helping to reduce the jail population if we meaning law enforcement, had a program where some of those inmates are trusted to them? They follow them, they mentor them, they monitor them, and in the process, we are reducing the inmates in the jail. And probably not, we wouldn't, I don't believe, zero in so much onto those that have a long criminal history, but many of those that might be sort of in between. Have we looked at that? Has that been explored, or is that something that we definitely believe just would not work?
Mr. Chair, Commissioner, we have a number of initiatives in our detention facility, but along the lines you just described, what we hope to do with the Council on the Status of Men and Boys is to build a much more robust front-end set of questions in the intake that seeks to find more information about the inmates coming in, particularly family issues that we don't currently do, asking, do you have children? How many children do you have? Are they yours? Are you with your wife? All those kind of questions we hope to dig into deeper with the notion of trying to then have those interventions both while they're in our care and custody, and extend those out to the community. That's in process. We currently do have, through our chaplain program in our detention facility, those opportunities. We shut those down during COVID, and we're in the process, hopefully, of getting those back up and running. We have pastors that are coming to the detention facility and ministering to those inmates. So we do some level of that today, but not quite to the level that I'd like to see us get to. And again, COVID sort of shut all of that down for us about 2.5 years now. But we hope to get back to some of that.
Yeah, follow.
Sure. What you talking to restorative justice in the sense of what you said, that working through the churches and all of that stuff?
In a sense, but I think it would be a little bit more deliberate is what I'm thinking about. As far as specific inmates, and of course you would do the analysis whether or not this would be a good fit, this person would be a good fit perhaps for this group or for this organization or for this faith-based entity, to embrace. And is it a good fit as far as the organization is concerned? Do you have experience with them? Are they a trusted entity that you have dealt with in the community that could help you in the sense of releasing that person in the hands of that particular group or groups?
Yes, ma'am. We hope to build I don't know if you're familiar with our Spirit platform. The Spirit platform allows us to put providers in, and then we want to connect the provider with the inmate with a particular given set of issues and problems. And that we're trying to do more on the front end during the intake process and with our Council on the Status of Men and Boys that we haven't done previously.
Right. And of course, as a follow-up, I know it's not something you could do unilaterally. It would have to be utilized in conjunction with the judges and with the state attorney as well. And so, same question, Mr. State Attorney.
Yeah, and I was asking to be called. That's obviously the judge sets the bond and will decide. I think that we are looking at exactly that model with pretrial, with the idea that if we had someone, often the people who are there need services, whether they be mental health, substance abuse, and a variety. So if we have a faith-based or other organization that wants to take care of them, then we can create a care plan. The sheriff, I know, would agree, once again, to create a modification of bond or a conversion to a pretrial where you have someone, we've done exactly that with other groups where, okay, you're going to make sure, unfortunately, particularly with our homeless population and others, that they have the services they need. So we are working that, but that would require a judge to modify the conditions of, probably convert them to pretrial to make sure that they follow the direction of whatever Good Samaritan wants to take them under their wing.
Can I ask Ms. Broxton, did we not have something similar with the Bethel? We had a formal arrangement through the PSCC with Lucretia Collins Group. Was that not a model of what is being lifted up tonight, right now?
It was to some extent, Commissioner. It was one that they worked with employability and provided those wraparound services that they needed. And some of them were released with pretrial conditions, and some were released on bond to go to reentry.
Okay, we've seen that model. It worked well, but as you pointed out, the credence of the sponsoring unit, their engagement and intensity of it, it really depends on the sponsoring agency and the personnel that they have pushing it with intensity. So, and I think that we all, I'm glad you lifted it up, and we contracted with them to provide that service with the PSCC. But it's loosey-goosey because it's not a formal, as you're pointing out, it's a volunteered, nuanced, empathetic. We recognize the Bethel model, and the state attorney signs off, the sheriff signs off, say we know them, but it's not a formal, institution-wise option.
And just one last question, Mr. Chair. I'm looking at the recommendations, and I support the recommendations, but I guess want to ask staff or maybe even law enforcement. When you look at option 4, developing a policy that would limit the amount of time a person discharged with the felony can be detained in a jail. And I would assume generally, Mr. State Attorney, Mr. Public Defender, that those individuals that are in jail now over 200 days charged with the felony either have no bond or can't make the bond, or they have waived speedy trial, perhaps. Are there other instances where they would still be in jail?
That's, you're correct. The majority of them, as you can see, you have 37, according to census date, were misdemeanors, so they're almost all felonies. Having spent time, Ms. Yuri and I did work pretty well together trying to get funding for our people. There were actually more motions at the state to send prisoners back to the county detention than to take our people. We've been playing defense, the sheriff and I, in trying to, where they're trying to have the jails handle state prisoners. So I think it's a good movement, but yes, we're working on that.
Okay, thank you. And so just one follow-up to that. So I guess my ultimate concern, and I don't have a problem with this working with FAC to see if something can be formalized, but I would think that there would be some exception, just like you can waive speedy trial, if there's a limit that's placed on the amount of time a person can be detained in jail. You got the judge involved, you got a lot of entities involved, but I would think that there would be some waiver on the part of the defendant, just like they can waive speedy trial, or Madam Public Defender.
Perhaps help me with that one. Hold on. I do think there's an important distinction to be made while we're talking about jail population specifically, which is that the majority of people sitting in jail have their presumption of innocence. They are waiting their day in trial. I don't think it's a fully accurate representation that just because someone's accused of a felony, they therefore aren't entitled to release. We do have clients that have bond amounts. And so if the state attorney would stipulate to reducing those bond amounts, that would be an immediate release of, almost 100 people or so. So that is something that we're litigating actively and are bringing up routinely in the court system, not just for our clients, but private lawyers are doing it as well. So I think we need to, look at specifically, just because someone's accused of a felony, remembering they haven't been convicted of it, at least not while they're sitting in the county jail.
Thank you. Can I ask the state attorney if yes?
Obviously, the purposes of bond are to protect the public. Some people, by their conduct, either have violated while on pretrial, or their crimes are so serious that they are not entitled to bond. As we've said, if you look at the numbers, and particularly one of the packets that I think is important at page 9 of your 29, if you look over the 2019 to 2022, murder has gone up, sexual offense has gone up, robbery has gone up, the drugs have gone down, burglary has gone down, theft and fraud has gone down. So once again, your criminal justice system is moving as you all want us to, with less violent going into the jail, and they're being offset, unfortunately. People who are in there are often looking at it, and that's what, to the sheriff's point, we'd like to get them, now that the courts are running full speed, we'd like to get them their trials as fast as we can, and then they will either be free or they can be moved to the state facility when they're sentenced.
So I just want to finally thank you guys for all the work that you do.
This is your third finally, you
keep
know.
us safe. This is my final to keep our county and our citizens safe, and we've got a tremendous amount of respect for all of you all, for all that you do. Thank you.
All right, Commissioner Dozier and Commissioner Minor.
Thank you, Mr. Chair. Thank you all for being here. I know we've been here, for some of you, all morning, so thank you for that. Good discussion so far, and I'm going to pick up on some of Commissioner Cummings' good questions. Obviously, much more experience in this area than many of us. I'm going to start with the proposed legislation, and we talked about this during briefing yesterday, and there was some discussion that we had about, and I think I don't know if you were getting there, Commissioner Cummings, with exceptions to this, but I want, so maybe you already asked this question, I want to reframe it a little bit. If we had limitations on the length of time that someone was in the detention facility, could possibly be moved someplace else before their trial date. Would that harm their ability to work with their lawyer or the public defender's office? I mean, would there be some challenges there? Yes, and I would love for both of you, but Public Defender Yuri, if you want to comment on that first, and then State Attorney. Thank you.
Sure. So I think the logistic piece of that is it would be difficult, obviously, for people who are being held in a state correctional facility pending resolution of their case. That's problematic. I think the simple way to explain it is we are sentencing people to prison having not been sentenced. And so I think that's incredibly problematic, specifically to prison conditions and how detrimental that can be to people's mental health and well-being. I think we have a unique perspective, myself and the private lawyers in our community, Commissioner Cummings, who know, I mean, we're talking with people and their families every single day while they are sitting incarcerated, waiting for their day in court, and they are maintaining their innocence, or they are saying, I am not guilty of this allegation, and we are reviewing the evidence. And ultimately, we are taking these cases to trial, and we are grateful for the jurors also that are coming back routinely with not guilty verdicts. And so that's a big piece we have to think about when we talk about sending people to prison before they've been convicted.
Thank you.
But once again, logistically, it's fairly, one of the great technologies we came out with COVID is the fact that we are not transporting quite as much between the detention and this building. So, I mean, I can tell you that's a major cost and security issue to the sheriff's office, just doing that little transport. If you had to do a transport from a correctional facility all the way back for every court appearance, I think it would be cost prohibitive. So I think I agree that we need to speed things up. That we really need to speed things up. Every one of the procedures in criminal procedure is that everyone has a right to a speedy trial within 175 days, unless, like Commissioner Cummings said, they waive that. So right now we're averaging 11 continuances per case. That's, if you're looking at an average of 30 days per continuance, that right there is a lot of time. We'd like to see those cases be resolved within 180 days. Once again, we can't waive speedy trial. That's a defendant's right. And so we're trying to move it up, but I don't want to do anything logistically that's going to slow down the progress where I've got to wait 2 weeks to get the offender here before a judge, or I got to wait for a jail transfer. Because prison, they will send them, they could be in Miami. And which again, that creates a problem for defense counsel who's based in Tallahassee. They need to visit their client.
Thank you. Sheriff McNeil, do you have anything to add to that, or I just want to give you a moment, sir, but.
As they said in law school, asked and answered, I guess.
But Commissioner Dozier, might I, on point, has there been a cost savings with virtual and especially first appearance being done on television set versus having to bring people physically before the court? You realize some reduction in cost, anxiety, have you not, Sheriff? I mean, new virtual technology has made that a lot more efficient and simple.
Yes, on the technology end, yes. I'm not sure the other context of your question, but
Well, the cost of gas has gone up, getting people out and cussing and fussing and.
I mean, during COVID, the fact that we did not transport as many people, I mean, we saw so many benefits of that environment. One, as you talked about, the cost of moving prisoners, the population in the detention facility. I mean, we had probably the most Gentile, if you will, population during that period of time than we have doing normal flow of inmates in and out of our detention facility.
I think they were scared. All right, Commissioner Dozier.
Thank you, Mr. Chair. Thank you for your comments. That really gets at, both of you, the heart of my concern about proceeding with the legislation with FAC. Mr. Johnson, we're going to be more formal. But you said that if we pass option 4, you would be bringing back some language after working with all the stakeholders and FAC at some future date for us to approve, and I assume that would be before the June FAC annual conference or the September legislative. Is that correct?
That's correct.
Okay. So for the maker of the motion, Mr. Vice Chair, that was you. I think on this one piece for option 4, I'm not sure I'm ready to move directly to drafting that legislation. I mean, there's a lot of concerns and questions in that. I can support option 4 so long as we bring back a full report on the concerns that we've heard today and maybe some nuance, the exceptions. And again, Commissioner Cummings, I'm not sure if that's what you were getting at, but any exception, that is, yes, ma'am, thank you. I was following you correctly then. Any exceptions to that a set time limit on keeping people at the detention center. Now, Mr. State Attorney, what you said about dealing with the state wanting to send people back to the county, I'd like to learn a little bit more about that as well. I mean, if we're dealing with our own population, just when we look at this issue and moving forward with potential legislative proposal or proposed legislation through FAC, I think that's an interesting area to get into as well. We got to manage our own population, but we certainly don't need folks coming back who have already been charged who should be in the state prison system, right? So.
Right. Well, yeah, unfunded, it's another unfunded mandate. And since I've been in those meetings across the street, I thought I should mention it to you all. I think it was 2 years ago, the sheriff will know, the Florida Sheriff's Association was pretty visceral in their response when they started talking about holding prisoners of a year and a day or 18 months in the county facilities because it would be such an extraordinary economic impact. But it is possible they could do it. And to the sheriff's point, to Commissioner Maddox's point, it's another reason why you may want to plan ahead because you never know, they may require us to hold them longer even.
Okay. Well, for the maker of the motion, Mr. Vice Chair, I would just say not limiting this discussion to just setting a time limit, but including exceptions, including reflection on some of the other factors that we've drawn out of the conversation today. I don't mind walking down that road and seeing what comes back to us, but I think we need to have more nuance in that legislative proposal. Okay, thank you, sir. Last thing, Mr. Chair, I know we're getting short on time here. For the consultant, I'll just concur with the discussion that already happened. I think the population issues that have been brought up are one thing, but also, Sheriff McNeil, I think you mentioned just a different population within the jail policy, if these are things that we need to reflect on in the future, not just the population growth of the community, but what type of people or what offenses they're committing. And while I want to really acknowledge, again, the challenges during COVID, I think I did that in our last workshop, the fact that we've been over 80% since the jail opened. This is not just COVID related, right? Or detention facility, forgive me. This isn't just COVID related. So it is something that I think we should move forward with that consultant review. I'm going to toss this out and not ask the vice chair to add it to his motion, but if there are any strategies for helping, this is only one part of it, but the courts, our public defender, our state attorney, I would be interested in any other options coming through this report in collaboration with you all to see if there's a way that we could help mitigate any other issues. We talked about civil citations before, we talked about diversion, those types of things. I'm not sure if you're willing to be part of that review and analysis. I think that, the way staff has described it right now is good, but this is a collaborative approach, and because the county is responsible for the facilities, for the courts, for the sheriff's department, for public defender, I mean, we do have a stake in this, and of course we have a stake in the best resources for those throughout our community, but certainly at the facility as well. So I'll just leave it there. I don't know if there's any comments on that piece, but if the consultant looks more broadly or finds other examples in other communities, I hope that we can have a more collaborative discussion about that. Thank you.
Thank you, Mr. Chairman. Appreciate it. And once again, thanks to everybody for being here, taking the time to meet with us today. I know how busy you all are, and thank you for everything that you're doing. Hopefully we're all entering a post-pandemic period now, and our clearance rates that we've discussed already are now at the state median level again, which is great. And in fact, they're 103.5%. So we're actually eating up into the backlog, which is terrific news. The question I have, it really centers around the consultant services item. And our county administrator discussed this a bit, so maybe this is a question directed at him, but also the sheriff and state attorney if you think it's necessary. So the consultant would analyze the current conditions of the detention center, take a look at trends, future projections, that type of thing. But we've just hopefully conquered a very volatile period with COVID and the pandemic. My question, I think I know the answer, but I want to hear what the responses are. Is this the right time for us to have a consultant take a look and try to do future projections before the dust has even really settled on COVID? There's so many, try to measure anything with regard to social issues. We always have that COVID period now that really skews anything we try to take a look at. So my question is a consulting study now really a good time to do? Maybe we don't want to do it anyway, but we're just now coming into a post-pandemic period. Is it the right time for us to try to take a look at the current situation and project future trends? Mr. County Administrator.
Mr. Chairman, Commissioner, I think we can factor that into the analysis.
Okay, yeah, that's pretty much the answer I thought you were going to give. But I felt, anytime $200,000 is a lot of money, and consultants.
How much is it?
Cheap. $200,000.
Yeah, that's a lot of money.
So consulting services are not cheap, and usually you get what you pay for. It's good quality analysis, but it's still something I wanted to discuss. Is there ever a good time? You try to let the dust settle. The dust has never really settled, is it? But that's really it. I guess the other follow-up question I had along that vein was, I know the state requires us to do a detention center assessment every year. You mentioned that, right? That focuses strictly on the condition of the existing structure, right? And whether it meets the current needs. Is that right?
And services.
Right. So that probably would be a big part of what the consultant does as input, but then the consultant services would focus on a wider scope than that, which is trying to take a look at maybe your assessment on the annual state required report, taking a look at what needs might be based on that report, but then looking at what future trends are, factoring in this post-pandemic world that we're now living in to try to anticipate what we might need for the future. Yes, sir. Mr. Chair.
Mr. Chairman, Commissioner, the question relative to whether we should do it now, I think begs to go back to the intention with which the facility was built to start with. And quite honestly, the structure of the building itself does not lend itself to the practices we currently conduct today. For example, most prisons are not direct contact. Ours is a direct contact facility. Even if we don't do this study, I'll be talking to staff about how do we now reconfigure our facility so that we don't place as many of our people detained, nor our staff, in harm's way, simply because of the way the building was built. And it was built as a detention facility. It was never built with the well, I'll put it this way, when I worked at the Department of Corrections, we wouldn't build one this way, even in a state prison, because of the staffing needs. The staffing needs for this facility far outstretch the number we have currently today. And for those reasons, not only that, but when you look at this from a mental health perspective, we're housing more mental health persons than were ever anticipated when this was built. And if anything, with respect to legislative issues, we should perhaps be looking at how do we ensure that the state takes those persons who we currently house, who should be in state mental institutions as opposed to being in our local detention facility. That's a legislative issue that warrants some degree of consideration.
Thank you, Sheriff. That's a really helpful answer. I appreciate it. And what the county administrator said, I mean, that's pretty much what I guess you were going to respond with. But still, I wanted to have some discussion about that. So that makes a lot of sense. I'll support option 3 as well as the other 3 options with the motion on the floor. Mr. Chairman, thank you very much.
Right. Thank you, Commissioners. I want to recognize Mr. Grant Sladen, Court Administrator Mr. Sladen. Sir, we thank you for your patience. You've been here through 2 workshops. And I failed to recognize previously. I hope our Scrivener will capture the presence of attendance of Mr. Sladen. The sheriff was actually looking on my notes here, and where I write legislatively, we need a mental health hospital / treatment facility. Or off note, we need some level 4, 5, 6 treatment facilities, which we do not have here. There's no question that the county's detention center is a homeless shelter, homeless ward. It's a mental health treatment, and it's a mental health ward. There's no doubt that it's an unemployment ward. There are a lot of health and sociological dynamics clustered, which spawn into and crosses the line into criminal conduct or misconduct. And our sheriff, thank God, is a tremendous steward of the responsibility of fanning out and making distinctions from mental to all those different things. I believe that what we have occurring with option number 3 is a conflict for me, because Mr. Mack and Mr. McCall are both here, and they know the PSCC is charged statutorily to do all we can to help to reduce and to mitigate against jail crowding and to reduce jail population. That's a statutory charge. And it would be almost hypocritical to the role you asked me to play in fighting that fight for reduction. It's necessary for me to face Mr. McCall and to face Mr. Mack at this table next month, and as well as Ms. Broxton, who serves as our coordinator. But I want very much for you to know that there is a need for a consultant, and I'm asking to make a motion to consider what we have not done. In the last month's meeting, the state attorney, the public defender, and the chief judge, Judge Allman, Judge Akins, and our PSCC, we met to talk about the dynamics of the 137 to 264. What makes and what is sparked the stay from 137 2019 to 264 2022. And frankly, I was not overly happy with what we were able to explicate as factors. I'm asking that a consultant, I'm not sure if this consultant would be qualified, but we need an evaluation of the jail clogging and to look at the efficiencies or the inefficiencies of case management, et cetera, those dynamics. And I think that with all due respect, Mr. Long, what is the percentage of money that of the county's budget goes to the sheriff, is under the sheriff's authority currently? What percent of our budget is under the sheriff's
Budget-wise?
authority?
Close to half.
40%. Okay. So we must think and realize that our city commission has torn a building down called the Northwood Mall, and they are in the process of building a new police station. The last numbers I heard was between 50 and 60 million. And those were pre-COVID numbers. And I'm not sure what the taxpayers of this community will end up paying for the same building right now. I imagine it's going to cross 100. I just imagine it will. If we do a report on number 3, I will not vote to build a new jail off a consultant's report. I will not vote for a jail off of some consultant. And there is no report that should come back to us in the interest of space needs that a former Secretary of Correction and our current sheriff's voice is not engaged, does not have a strong input on, and one who knows standards and has been over the standards for correctional facilities across the entire breadth of 67 counties in Florida. If he was not the expert in these areas, then it really wouldn't matter. But if you got Coach John Wooten and he's available to coach a basketball team, wouldn't you really rather have him? Wouldn't you really rather have? So that consultant, until sheriff reviews that work, agrees to the subtleties of what women, men, mixed sex, all of those requirements, I need his mind on it. Secondly, I will not support, even on his recommendation, it ought to be a referendum, because we're asking the citizens of this community to pay for a police station that's going north of 100. And if we build a new jail, it's going to go north of 100. And I think that should be a referendum item. And I think that ought to be stipulated, that we would bind ourselves to respect the pocketbooks. And our sheriff is already getting 40% of our dollars. And this would just, like, how do you say it? I mean, it would really be over a lot. The training sessions of the state attorney and TPD, I'm able to identify that a lot of the problems at the jail is that the percentage of arrests made by officers in this community is not sheriff's deputies, it's police officers. And our contact, our connection with a unionized officer force, we have none. Yet it's almost like unconsciously policing can occur outside the context of nebulous charges which add to the bottom line that county commissioners pay for. And to the extent that those who are writing the tickets and arresting the folk are disconnected to what we deal with is just an amazing vacuum. But my hope is that the state attorney would insist in those areas of discretion in talking with TPD to make sure that on those areas, and maybe I'm blending the two previous session with this one, but that there are workshops, engagement, training, that, because not all officers are created equal in perceptions of who's a good guy and worth discretion. And then, commissioners, I want, according to my notes, I find it that it might be important for a consultant to look at the cost of renting space from Jefferson County and renting space from Wakulla County and us leasing some cells versus the cost of building cells on the dirt in Leon County. Location, it may be much cheaper. I think the last numbers at the PSCC sheriff we got was like $40-some. Was it $40-some a night?
For Walton, it's 54, but we considered $94 a night. It would be anywhere from 54.
We're not going to Walton.
No,
We're
going
not
to
taking
Walton.
people
No.
to a place with a Confederate flag on top of the jail. That's not going to happen. We're talking about Monticello. I'm talking about Jefferson and Wakulla. Those numbers were like, I'll say $50 a night.
Commissioner, the problem with the local surrounding jurisdiction is they do not have the amount of space like we have. We would quickly take over their space, and then we would still be at the same. And then we add on the additional transporting, medical calls, feeding, all of that has to be transferred to those counties, which then we would have to pay for. It's cheaper if we're able to do it here. So there's a lot more things going involved than just merely pushing them out, because a lot of counties won't accept them because they just don't have the staffing or the manpower or the room to be able to do it.
Okay. I'm just basing my thoughts on data that was brought to the PSCC with respect to overnight costs that we have paid Jefferson and paid Wakulla to hold some of our what's the word? Detainees. That's the word, not inmates, detainees. So I like for that. I'm just a commissioner. Those are the things that I would like to see, a comparative analysis of leasing space from those counties. And then, Commissioner, my final, Commissioner Mattis is feeding us today, and I'm grateful, and we're not going to delay that. It's interesting that Ohio has given up on gun control, and last week there's no requirement to carry a permit or have to secure a permit, just whosoever will let them carry. That occurred in Ohio. It's going to be interesting to see how that plays out. And I just find it, as a nation that loves the Second Amendment, and many of the offenses for felonies involve guns, that undergirding some criminal conduct is this manic support for the right of guns, the ease with which people have access to guns. In our nation, in our county, we're strong gun advocates. And yet, somebody mentioned this morning about how marijuana shows up in association with crime. How many times does guns show up in association with crime? And our nation has a greater interest in the access of citizens having guns than our nation has an interest in citizens having access to mental health, access to education, access to housing or employment. And that is an indictment upon all of us, that our commitment and visceral support for guns, which play out in us being here today on this conversation, is a stronger commitment than mental health and homelessness, giving people a house. So, Commissioner Dozier, your question of option 4, I heard you But realistically, the thing with option 4, we agree on rattling its cage, but for different reasons. I find sometimes that when you try to work with the Florida Association of Counties, unless the bigs are down for it, North Florida don't have a chance. So unless the big counties, and our Florida Association president is sitting right next to me, unless the big counties are down, the rest of us, we're almost voiceless up here in North Florida. So that's why option 4 to me is, so to make the motion, my ask is that we have the consultant to evaluate the jail clogging issues and looking specifically at the 137. How do we get to 264? What can we do to mitigate on that number? That's the ask for the maker.
Mr. Administrator, would that not be included in the further mitigating the need for additional infrastructure?
We'll be sure to include that.
Okay, thank you.
Okay. All right, thank you very much. Are there any other observations? Hearing none, we want to thank you all for a tremendous day. This has been a red letter day in the history of Leon County, and persons may little remember what was said here, but they're going to long remember what was done. So thank you for
Mr. Chairman?
all that you've done. Yes.
Once you're done, sir, I just had a quick comment.
Mr. Minor, yes, sir.
Thank you very much. Well, many of you know Monica Casey from WCTV. She began covering local government here about 3 years ago. Well, we just learned she's going to be leaving us on April 7th to go to Raleigh, Durham, which is a really big promotion in the journalistic world. So congratulations, Monica. It's been a pleasure working with you. And wish
I
you
make
luck.
a motion that we pass that Monica not go nowhere. Monica, we bid you fairly well. Congratulations. You've been a tremendous reporter. And I'm so glad you've gone, because every time I see you, you just make me nervous. I just don't know. Oh, Commissioner. We want to thank you all again. Sheriff, your big shoulders, your broad mind. We thank you. We thank the state attorney. We thank our staff and all others.
All those in favor of the motion on the floor indicate by saying aye.
Thank you.
Any opposed? Motion carries without objection.
Let's go.